I've already said. Non-prosecution. Non-prosecution.
Malad upgradation, Malad 2035. Malad petitioner is a PH candidate. Malad there is a
Hand
vacancy.
over the slip, please.
Malad only one thing. Malad the PH candidate there is a vacancy still now. Malad please Malad kindly upgrade in a position so
Sir,
that
hand
matter
over
can be
the
heard.
slip.
Yes, Malad. I am handing over the slip. Malad the predicament. Malad I have to mention orally on this aspect only. There is a vacancy. That's why, Malad, I am requesting before your lordship to take up the matter. Malad, item number 2035, Malad. I have given this.
I will not memorize you. I can tell you. If the slip is there, it will be taken up.
May I have your lordship leave to mention one matter for non-prosecution? Non-prosecution.
My lord, I am praying for a leave, my lord. This is, my lord, regarding second SLST, my lord. The petitioner is a successful candidate, and in the final stage, the petitioner is cancelled that the EWS certificate. But in the meantime, in the oral interview, the all documents are verified and accepted. But thereafter, petitioner noticed that he is removed from the EWS list, my lord.
Yes.
While praying for leave, my lord. Second SLST, my lord.
Right, leave Thursday.
Grateful, my lord.
Service.
Yes, my lord.
Item number 1487.
Is it affirmed?
I will
Affirm it and then give.
Item number 1487. It is a madrasa matter.
1487.
Page 61.
1487.
87.
Released. For want of determination.
1487.
Give your name.
Okay.
Your lordship, I am praying for why not the election process was completed, a panel was published, panel was not given a signature. I was the substitute candidate. The post is remaining vacant, nothing has happened there.
What will I do by hearing all this? Inclusion slips have been taken.
Upon your lordship permission, I am mentioning my matter for inclusion. This is a contempt application, your lordship. Order passed by your lordship 1st July 2025, but it has not been complied, your lordship.
Slips for inclusion are being taken.
My lord, last month I mentioned one matter, old matter, my lord. My lord, please to take up this matter, my lord. File is here, but the matter is not appearing. By some urgency is this, my lord? My client is retired.
প্রভু দেখুন তো ফাইল আছে বলছে Yes.
This matter was pursuant to the order of the coordinate page. The coordinate directed the DI concerned to ascertain the vacancy and transfer the petitioner. Vacancy was ascertained. DI asked the petitioner to exercise option. Option was also exercised. Since the petition is pending, they are not giving effect.
What is to be done? Non-prosecution?
No, my lord. Direct the since pursuant to the earlier orders from the court, let transfer be.
Who is the other side?
No, that's the suburbs.
Who is, where is the matter? Where is the matter?
Not in the list.
এটাকে নিয়ে to be mentioned দেবেন তো? Serve notice upon your other side.
May I have your lordship's kindly to mention my application. Lordship,
Why are you mentioning?
the urgency is the petitioner was a retired headmaster. The retired headmaster, he has retired in 2023. But after retirement, he has not.
What inclusion?
Yes, inclusion under the application.
Slip.
Taken out the application.
If the application number is there and it's mentioned on top application, it will appear in the application list.
Only for release of gratuity.
Whatever, only or whatever.
I got an application for.
Sir, hand over the slip.
My lord, may I be permitted to mention, my lord, restoration application, my lord.
No, no slips now. Go.
Oh, inclusion.
No, sorry, nothing doing.
My lord, your lordship's officer told that I have to mention, my lord.
The moment I sat, I mentioned that hand over slips. If you have not heard it, please
No,
come.
no, my lord,
Month,
your lordship's officer tells us that this is the
500 slips have been
this is the
collected. No
application,
further.
my lord. Your lordship's officer told me that I have to mention, my lord.
Yes, nothing doing.
But kindly,
Yes.
my lord, kindly, my lord. Kindly, my lord.
Ninita?
I was waiting, my lord.
Yes.
One extremely urgent day. The urgency is, it pertains to Gyan Bharati school. Despite there being, repeated endeavors made by the DI and, which was foiled, at our instance by writing letters.
Who are you representing?
The school.
All right.
The secretary. They have called for a hearing once again today.
Who? They means who?
The DI of schools, Ssc, without disclosure of any documents, without disclosing any complaints. First of all, it's a private school managed by a trust.
All right.
My lord, it's not unaided issue. Internal affairs, my lord, cannot ordinarily be looked into apart from, my lord, the syllabus and everything. Academic issues. This is not an academic issue.
Was anything pending before the DI?
Nothing was pending.
All on a sudden,
My
they
lord,
did.
times previously, we let us. Thereafter, my lord, on the 29th, they once again served on us. My lord, we received it. We have come to your lordship in the hearing. May I come back at any time, my lord, after affirming and giving.
What are you apprehending? Why are you rushing to court? What type of action?
My lord, they are saying that there are allegations of alleged defalcation, alleged fraud, my lord, in accounts. My lord, despite, my lord, we disclosing our audited accounts, we disclosing everything. Form 4C, everything has been disclosed. Thereafter, they are really.
No, but then
I shall
the
serve the
fact
DI.
that you are saying I will not interfere immediately, you file it in the department.
My lord, today is
It
the
will,
hearing.
doesn't matter whatever the hearing is, it will be always subject to the result of the writ petition. You file it in the department, it will appear in the list on Wednesday.
My lord, instead,
L-
my lord,
leave.
may it appear tomorrow.
Leave. Wednesday it will appear. Take leave. Where is the matter?
My lord, the matter is here. My lord.
Is it affirmed?
No, no.
No.
I'm
Get
getting
it
it
affirmed.
My lord, then in that
Or-
event, since your lordship is, my lord, there's Wednesday, there's some uncertainty, my lord, Thursday.
Thursday? Wednesday uncertain?
My lord, insofar as I am, it may be.
All right. Thursday. You
My lord, I shall
affirm
indicate to
it
them.
and file it.
My lord, I shall indicate to them by way of letter that, my lord, the matter has been, my lord, mentioned, and, my lord, the hearing is fixed on Thursday. Grateful.
Under extreme urgency, I'm mentioning item number 1979 of the Lordship today's list. But what has happened? The petitioner is
I do not know or do not want to know what has happened.
emergency marriage is student of class 10 CBSC. He met with an accident, got his leg operated. He could not attend the classes properly. Now he is not being allowed to sit for the board exams. Board exams starting from 7.
If I do not know, there must be some percentage for attendance or something. That is the reason.
Percentage is the matter, but we
Then-
had informed the school all the time that he is going through a fracture a leg. Then he got operated. School was all the time informed. A school has in fact requested CBSE for this condonation, but they are not permitting. My lord. Kindly, my lord. It's about career of a child, my lord.
Thursday. Intimate all your other side.
I'm deeply
But under compelling circumstances, may I pray for a leave, my lord, to file this writ petition? But pursuant to this honorable court's order, my lord, transfer or recommendation has been issued in favor of the petition to a school which she never applied. Rather, the schools she applied are, my lord, vacant. The schools themselves by letters say that. My lord, now, since the recommendation is issued, the board will be issuing the transfer order. So this is what is the urgency.
No, but then why is she not joining where she has been recommended?
Because that is, my lord, away. And my lord, these schools that she chose, my lord, those schools are closed. Not only closed, they are vacant. My lord, that is evident from those schools' letters itself, which have annexed in the writ petition. If
Thursday it will appear, obtain leave
grateful, man.
and serve notice.
Absolutely.
My lord, subject to your lordship's sanction, may I be permitted one matter, my lord, for upgradation 1669. Why I am upgrading, my lord? This is matter relates to interest on gratuity and arrears salary only.
Hmm.
Senior citizen, interest on gratuity and arrears salary.
You hand over the slip upgradation and mention over there on top.
1669.
I cannot memorize. You write it on.
Yes, my lord.
My lord, contempt application, my lord, violation of a lordship order.
No further. 500, more than 500 slips accepted. Come next month. Cannot help.
Lordship.
I have accepted so many slips. Why are you waiting for mentioning? Slightly?
Well,
And I have refused one of your friends. নিয়ে নিন ওনারটাও নিয়ে নিন তাহলে এটা নিয়ে নিন ব্যাস
my lord.
আপগ্রেডেশন
My lord, it is my lord, upgradation. My lord, matter, my lord, I am mentioning the matter for upgradation. It is urgent.
give
Lordship, this is for recall. I tried.
Ladyship, may I be permitted to mention one matter, Ladyship?
yes
Uh,
yes
Ladyship was pleased to dispose of two applications where the state has preferred an appeal before the Honorable Division Bench. And pursuant to the leave of Honorable Division Bench, matter has come before your lordships for review. Now state is not mentioning the matter, nothing is coming. My all post-retirement benefit has been stalled by the way of filing a review.
Yes, so what is to be done?
Ladyship, I want the matter to be heard.
It will be hard. If it is there in the list, it will be hard. You have
No,
to
it is not in the list. I am praying for inclusion, Ladyship.
give the number.
My junior must be there, Ladyship.
If junior is there, then the number must then hand over the slip. Already it has been handed over.
Grateful, Ladyship.
For what?
Only your lordship's order.
Inclusion. All slips have been handed over.
Last week, because your lordship not accepted much.
Second February আমি মার্চ হয়েছে
এটা একটু
ডেটটা
কিসের date?
মার্চ হয়েছে
কি?
In this matter, I
Secondary
am
for your
protested,
lordship.
led by Mr. Shukla Chattopadhyay.
এটা মার্চ হয়ে গেছে? অলরাইট, ঠিক আছে, এটাকে ইয়ে করে দেবেন, ফেব্রুয়ারি হয়ে যাবে।
Let may I come back tomorrow?
কেন?
There is
Today
some
is 2nd of February,
yes.
right? What is the matter about?
Well, this is regarding that matter where the headmistress has been transferred. Well, I could not able to discharge my duty on 16th of September. Well, I was beaten up inside the school. And the Commissioner of School Education, I prayed for an order from this court for transfer. This court directed the commissioner to consider. The commissioner considered and transferred me. Now, the deputy secretary jump up into the issue.
What is the instruction?
The deputy secretary.
What does it say?
Well, commissioner have, I have just received. Commissioner have cancelled the transfer order and rejected for proceeding against the petitioner because there are a lot of allegations against the petitioner. And board has already issued a show cause notice to her.
No, not show cause. Board has suspended me.
No, my instruction is show
There
cause.
are allegations
I have received
against
the
you.
suspension.
There are allegations against you, and
Yes.
the order of transfer has been cancelled by the commissioner.
The order
also.
of transfer, which was before your lordship, I prayed for implementation.
That has been cancelled.
During the pendency of the writ petition.
Yes.
Since session of the matter. For 2 months, the court is taking up the matter and Mr. Chattopadhyay is asking for time.
Please come.
Well, may I get the order of this, the commissioner? I did not get the order. Devi, Didi?
Learned advocate representing the Commissioner of School Education. Learned advocate representing the state respondents relies upon the instruction forwarded by the Commissioner of School Education signed on 30th January 2026.
Well, may I only take your lordship's 1 minute time? This was the letter of the DI of 19th of September. Kindly have a look to the order of the High Court. After this letter, the High Court directed the Commissioner to consider the prayer of transfer. The Commissioner considered the prayer in the month of December, 19th of December, passed the order of transfer. Well, now he is referring to the order of the DI of 19th of September. How this can be acted upon? The High Court's order is annexed to the petition.
Wherefrom it appears that on receipt of a detailed report from the District Inspector of Schools, Secondary Education, North 24 Parganas, that the petitioner failed to discharge her duties properly, resulting in administrative failure, for which the respondent authority intends to initiate disciplinary action against her instead of permitting her to be transferred to some other school. Stop paragraph. It appears that the formal order cancelling the order of transfer of the petitioner has not been served upon the petitioner till date.
Yes, yes, it has been transferred.
Cancelling the order of transfer. Stop. Next. Let the order of cancellation of transfer be immediately communicated to the petitioner. Stop.
My lord, may I only take your lordship 1 minute time? My lord, kindly have a look to the affidavit, supplementary affidavit filed by me. Only one request. My lord, the third supplementary affidavit affirmed on, my lord, the month of January, my lord, if you
9th January 26.
Yes. My lord, kindly have a look to page 5.
Yes.
My lord, this is the Deputy Secretary's order. Paragraph 3. Initially, my lord, got it?
Yes.
Initially, the authority decided to transfer the incumbent while contemplating the disciplinary proceeding on apprehension that her presence in the place might influence the course of inquiry. But later on, it has been found that the nature of allegation against the incumbents do not require immediate transfer, and the presence of the incumbent would not hamper the course of proceeding. As such, the transfer order has been kept in abeyance in order to maintain principles of natural justice. So, the Deputy Secretary is praying for, but I may be continue as the headmistress. Now, the Commissioner's order, kindly have a look. This Deputy Secretary has created all the mess.
Whatever. Now this has to be looked into. The respondents are directed to file affidavit in opposition to the writ petition.
May I come back with the fresh writ petition, because in this writ petition,
that will be nice. It
can be stretched.
As the cause of action for which the writ petition was filed no longer survives,
yes,
and fresh cause of action has arisen with the issuance of the order of cancellation of the transfer of the petitioner, accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. The writ petition accordingly stands disposed of. Stop. It will be open for the petitioner to initiate fresh proceeding in accordance with law, if so advised.
Man, grateful.
আরেকটা জিনিস ওই কারেকশনটা করে দিতে হবে
Mr. Bandyopadhyay is there.
Yes.
Affidavit of service, my lord.
I'm actually.
My lord, kindly turn page number 64, 65, and 66. That's the subject matter of the instant writ petition. First, my lord, page number 64.
Yes.
This is provisional waiting list under second SLST. Got it, my lord?
Yes.
The petitioner experience marks 4 was given. Monty Das entry number 3, serial number 3. Got it, my lord?
Yes.
Experience marks 4 was given. Very next page, page number 65. The experience number, there is 0. The bottom. Got it, my lord?
Yes.
My lord, kindly turn page number 66.
When was the provisional waiting list page 64 published?
My lord, just previous page, notification is there. 21st January 2026, my lord.
All right. 21st January 26.
Page number 63.
And 65 published?
Same, my lord.
Same day?
My lord, first page number 64 was published by the West Bengal Central School Service Commission. Thereafter, within few hours, the second page, that is page number 65, is by the West Bengal Central School Service Commission, which is very important, my lord, because the kindly see the advertisement, sorry, notification given by the West Bengal Central School Service Commission on 21st January 2026. I just read the notification, 3-line notification. The merit list within bracket panel and waiting list for class level 11 to 12 in second state level selection test 2025 80 assistant teacher for recruitment of assistant teacher in government aided sponsor school in West Bengal is hereby published today, that is such and such date. So this is done by the West Bengal Central School Service Commission. Kindly turn, my lord, page number 66.
Yes.
This is, my lord, heading, my lord, preliminary interview list under second SLST 2025. So this is, my lord, interview list. My lord, kindly see Monty Das entry number 17.
Yes.
Experience number 4 was given. So in interview list, experience number was given. Even in waiting list, first time, experience number was given. Within few hours, experience number just omitted, my lord. Now kindly see, my lord, the rule position, which is annexed with my representation, page number 24. Rule 11. Sub-rule 11 onwards, my lord, page number 29.
Yes.
Because second SLST, in the first SLST, there was no role of regional commission. In the second SLST, the government fixed the role of the regional commission as well as the central commission, which is evident from this rule, my lord. First, my lord, rule framed under Section 17, subsection 1 and Section 8, clause D of Section 2 of subsection 2 of Section 17. That means government framed the rule. The central commission as well as the regional commission, both are the mere executor of that rule. Nothing more, nothing less. But kindly turn page number 29. That is sub-rule 11. I just read the sub-rule 11 onwards, my lord, which is pertinent to mention. I think so. Sub-rule 11. I start from sub-rule 10, my lord. The preliminary list of shortlisted candidates prepared by the Central Commission shall be forwarded to the respective regional commission. So, the person, I just give the demonstration, what is the rule all about. First, the Central Commission, they prepare the preliminary list from the online application and they send it to the respective regional commission. Thereafter, my lord, it is mentioned, thereafter, the regional commission shall verify the credential and eligibility of the shortlisted candidate appearing for the interview. That is happened pre-interview. So, regional commission, they verify the credential and they will shortlist the candidate for appear in the interview vis-a-vis their application prior to conducting the interview. Application whose credential have been checked, found incorrect by the regional commission, and candidate who are found ineligible to participate in the selection process shall not be allowed to appear in the interview. So, who will judge, who will verify the credential? The regional commission, not by the central commission. That power is not given. Now, my lord, kindly see the respective, I just skip some of the rule. What is the respective position, my lord? Rule 15. Thereafter, Central Commission shall prepare a consolidated interview list which shall be published and be forwarded to the interview board as specific in Schedule 3. So there is no such role of the Central Commission to verify the credential. Thereafter, my lord, Rule 16. After interview, the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list categorized on the basis of merit as per Schedule 2. The merit list shall contain the name of all eligible candidates who have appeared for interview. Now, my lord, the very next rule. The Central Commission shall also prepare and publish in their website a panel of a candidate category-wise equal to the number of the vacancies, a category-wise waiting list from the rest of the candidates from the merit list who have not been included in the panel but included in the merit list. But there is no such role. From the rule, it is evident that the Central Commission have that power to alter the merit position. If they say so, that we found something, they can say it is by inherent power, but that power is not given. Any of the rule. I can demonstrate, my lord, that yes, I have that experience marks. But before that, the Central Commission ought to show how they empowered to alter the marks was given by the expert. The marks was given by the regional commission. Verification of my credential according to the rule, empowerment with the regional commission, not with the central commission. So regional commission, after verifying my credential, they give 4 marks. I asked this question to myself, whether the central commission asks from the regional commission, how could you give that 4 marks? Have they sent this letter to the regional commission? If they send it, placed it. Number 1. Number 2, there is no such provision in the whole rule to alter the marks by the central commission, because central commission power is restricted herein. They just published everything because the statute is very specific, my lord. I can show the statute. Because according to the statute definition section, my lord, Ssc Act 1997. It will be headmaster manual. Well, I believe 490. Page number 490. Education manual. Education manual. Education manual, volume 1. Page number 4. এই উপরে আছে, এই তো সামনে।
এই নীল বইটাতে আছে।
Yes. 490.
No.
Tax হবে। যাই হোক, আচ্ছা। 2C, my lord, definition section 2C. Central Commission means the West Bengal Central School Service Commission constituted under section 3. 2L, Regional Commission means the West Bengal Regional School Service Commission constituted under section 3. My lord, section 3 is very specific. Constitution of Commission. There shall be a Central Commission by the name of the West Bengal Central School Service Commission. B. A regional commission by the name of the West Bengal Regional School Service Commission in respect of each of the region referred to in subsection 2. For the purpose of clause B of subsection 1, the territory of the state of West Bengal shall comprises 7 regions to be called the Eastern Region, Southern Region, Southeastern Region, Western Region, Northern Region, Northeastern Region, and the Hill Region. Each such region shall comprise such district or part of a district as the state government may, by notification, determine the territorial jurisdiction of a regional commission shall be constituted accordingly. Thereafter, subsection 3 and subsection 4, specifically subsection 4 is all about the consist of 7 members of the Central Commission and the Regional Commission. They are all independent in nature, my lord. So Regional Commission Act, which is given by the statute, Central Commission can't alter it. If they want to alter it, then they have to take appropriate action. I will not say what would be the appropriate action, my lord, because but it is given to the statute itself. Now, my lord, the statute is very clear that there is no such power given to the centralized this court, my lord, about their power, whether they have that power or not under the rule. Number one. Number two is that, my lord, yes, the petitioner herein, I annex all the document because I inquired from her, sorry. Whether he got 4 marks, whether he is genuine candidate or not. I annex that, my lord, which is evident from page number 54 and 57. That is the experience marks. She was a deputed teacher of 2 schools, which is evident from page number 54. Approval of appointment is given, page number 54 and 57. In one school, it is 8 months, and another school, it is 9 months, which is evident from the document itself. What happened in deputed teacher, my lord? Suppose a teacher of a school want to pursue his training qualification, 2 years B.Ed training qualification, he or she went to that training institute. For that reason, the DI called for other teacher, and he or she have given the full benefit as a teacher, and he also have that responsibility of a full-time teacher. And I believe they gave the number to the other deputed teacher.
You did not implead the Regional Service Commissioner's party?
Not, my lord, because not required, because I am not aggrieved by the Regional Service Commission's action. I am aggrieved by the Central School Service Commission action.
All right, I've followed.
My lord, one thing, I just, because of that, my lord, that argument might came up, that he not complete the 1 year. For that reason, we not given the marks, the Central Commission, because it is our inherent power. With greatest of respect, my lord, suppose a candidate in one school, he done 11 months, 29 days, and another school, he also complete 11 months, 29 days. She will not entitle any marks according to their interpretation. Because I follow their interpretation in others matter. But a person who complete only 12 months, he is entitled for marks. Is it reasonable? I ask this question. Number one. Number two, there another argument is that might be.
Number one is not finished at all. Our number one is continuing for half an hour. 1, 2, 3, 4, 5 points, number one. How are we enjoying, Mr. Samim, now?
Yes.
The next point is that, my lord.
Number one is completed.
The next point is that, my lord, they can say that we treated everyone equally. If they done something wrong and wrongfully treated everyone treated equally, that is not sustainable in the eye of law. There are several judgments in this regard. So my first point is that, my lord, the Central Commission have no power to alter the marks. My second point is that, my lord, he completed more than 1 year. So she is entitled the marks. Number three, that point is not sustainable, that we treated equally to every candidate, and that too wrongfully. And not only that, my lord, fractional marks, my lord.
Here, interim order cannot be granted. Let them file their report by way of affidavit. The petitioner questions the.
Lord, I am saying that no merit is there in the petition.
All right.
So give the chance.
Yes.
Or I will file affidavit, whatever it may be. There's no merit in this substance at all. From the face of it, I can show it to you.
Jurisdiction of the Central.
But the question of, would your lordships kindly hear me for the jurisdiction issue? There's no jurisdiction.
File by way of an affidavit, we'll see.
If you kindly record my submission, there is no substance and there is no jurisdiction.
I'll record your submission.
Yes.
Central School Service Commission in altering the marks awarded on account of prior teaching experience. It has been submitted that the West Bengal Central School Service Commission published the provisional waiting list on 21st January 2026 by granting 4 marks on account of prior teaching experience to the petitioner. Step. On the same date, within a couple of hours, another provisional waiting list was published, wherein the marks on account of prior teaching experience was shown as 0. Step. According to the petitioner, the a further preliminary interview list was published by the Central School Service Commission, where the marks on account of prior teaching experience has again been shown as 4. Stop. According to the petitioner, the Central School Service Commission does not have any power to alter the marks given by the Regional Commission. Stop. The petitioner contends that it is for the Regional Commission to verify credentials and eligibility of the shortlisted candidates prior to conducting the interview. Stop. After the Regional Service Commission verified the credential of the candidate, and allotted marks on account of prior teaching experience, the Central Commission could not have deducted marks on account of prior teaching experience. Stop. Paragraph. The petitioner prays for a direction upon the Central School Service Commission to treat her as an impaneled candidate for interview by adding up marks on account of prior teaching experience. Stop. The aforesaid submission and prayer is opposed by the learned senior counsel representing the commission. Stop. It has been submitted that the writ petition does not have any merits and is liable to be dismissed ab initio. Stop. Next. The issue of grant of marks on account of prior teaching experience is under active consideration before this court. Stop. Next. To decide the issue, to decide the issue in the instant writ petition, the respondents are directed to file their report by way of an affidavit within a period of 4 weeks, reply if any within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. The issue of maintainability of the writ petition as raised by the respondents are left open to be decided at the time of final hearing.
May I request one thing,
Affidavit of service taken in court.
Instead of liberty to mention any
Date. In 4 weeks and 2 weeks, let us see what happens. The other matters are also there.
Because she is waitlisted candidate, my lord. She might got opportunity. It will be kind enough, my lord. One line has abide by the result of the otherwise, my lord.
Any steps taken?
She is her name is in the waiting list number 3.
Is taken by the commission during the pendency of the writ petition in respect of the candidature of the petitioner shall abide by the result of the writ petition. Yes, next.
Pardon me, Miller. Due to the wrong bus, I get late, Miller. Party for inclusion in the list, Miller.
My lord, under compelling circumstances, I have mentioned, my lord, I also come late, my lord.
Nothing doing.
My lord,
Sorry,
my
no.
lord, pension matter, my lord. Pension has been stopped, my lord. 28th date is for my daughter's ceremony, my lord. Marriage ceremony.
In the midst of the list you are mentioning.
My lord, yes, my lord, pardon me, my lord, because due to my lord, unavoidable circumstances, I come late, my lord. My lord, pardon me, my lord.
Take it.
Petition.
Yes.
For a time for the petitioner. ma'am.
Obligation.
Well, item number 3, I am praying for 2 prayers which are directly not connected with the ongoing recruitment process, but which will have some indirect effect. If I get a relief here in this petition, I may get those reliefs. My lord, I am a candidate who have been categorized as a tainted by West Bengal School Service Commission under the heading Weimar mismatch category. My lord, I read the Supreme Court judgment. I read the High Court judgment too. And also, after reading the Supreme Court judgment and High Court judgment, I found that there was the intention of the Honorable Supreme Court to categorize the tainted candidates amongst the Weimar, blank Weimar category, panel expiry category, and out of panel category. There is no exclusive mention of Weimar mismatch category in the Supreme Court judgment. The Supreme Court judgment, in my humble submission, my lord, it says that Supreme Court has
See,
not.
one thing, your prayer I can see is issuance of mandamus commanding the respondents to exclude the name of the petitioner from the list of tainted candidates.
Yes,
this court has dismissed writ petitions, several, not one.
But here, Lordship, kindly hear me for a moment, my lord. Possibly I am in a better footing, my lord. I went before the competent criminal court, before the Alipur CBI court, special court. I made an application. That's a scar on me. It's a scar because I cannot apply for any other job, not under the SSC, anywhere. My life is totally blocked. So I went before that court. I made an application. Kindly come to page 182. Volume 2, 182. And the Honorable Learned Court below, kindly come to page 182, my lord.
Yes. It's a list.
My lord, kindly I'm coming to that paper. 187, my lord.
187.
কোথায় দিচ্ছ এই বলো একটু দেখে
Yes.
190.
190?
Yes, of the volume.
Yes, yes, 190. Directing the CBI to supply all documents and to provide with an update comprehensive report. 190.
Kindly come to বলে 2 নম্বর ভলিউমটা দাও
191.
191, my lord, kindly come.
আগে দেখে নে
194. First, the intent to move an application. One 194 is a court's order. There is nothing there.
Yes, my lord. One applicant, Devashish Korun, Susanto 194.
Yes,
Susanto Maiti Kisholay Manna put up application along with fresh Wakalatnama, stating they intend to move an application praying to directed the CBI to supply relied upon documents in the proceeding and to provide a comprehensive report regarding the status and finding of the forensic examination of the list of material objects of the case. Learned advocate submits that he is not one of the tainted candidates and tag tainted candidates has been put upon him forcibly and they are without job at present and very without salary for month. Learned advocate draws the attention of the court to section 2WA of the CRPC of the victim has been defined. He submits that the applications have suffered loss and injury and categorizes themselves as victim. Section 207 and 208 of CRPC are only provisions to deal with supply of the copy. But both these two provisions deals with the supply of the copies to the accused persons. The applicants are neither the accused nor the witness in this case. Therefore, the prayer contradicted in the petition has no basis. Hence, the put-up petition is rejected. My lord, kindly now read the observations of the Honorable Justice Boshar's judgment. And that has been reflected by
in the Honorable Supreme Court's judgment also. My lord, kindly come to page 101 once. Supreme Court judgment in 101. First, my lord, kindly come to Supreme Court judgment once. Volume number 1, page 101, which says, my lord, CBI will undertake further investigation in respect of all the 4 cases. CBI will interrogate all persons who had received appointments beyond the panel after expiry of panel and after submitting blank OMR sheets. If necessary, CBI shall undertake custodial interrogation in respect of each of them. I have never been interrogated by CBI. So I am not falling within any of these 3 categories. My lord, why I am mentioning it, my lord? Supreme Court had quoted the division bench's order in this paragraph, that 363 in page 100. Lordship, kindly come to Roman 4. Persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR sheets but obtained appointments. My lord, this to be read with clause 1. Clause 2. All appointments granted in the selection process involving being violate Article 14 and 16 of the Constitution of India are declared null and void and cancelled. Well, this is the baseline of the equality in this judgment. Every job is gone. This has to be read in my humble submission, subject to correction. Persons who had been appointed outside the panel. All appointment, 1 is outside panel, after expiry panel, and OMR mismatch. Then, Lordship, kindly read it with 7. CBI will undertake further investigation in respect of all of the 4 cases, including all appointed candidates. CBI will interrogate, specifically mentioned, investigation and interrogation, Lordship, is different. Interrogation is mentioned all persons who had received appointments beyond the panel, expiry panel, after submitting blank OMR sheets. So, my lord, I have never been interrogated by the CBI. Till I am also found to be a tainted candidate. My lord, how far that is justified? One question. Number 2, my lord, kindly come to paragraph 35 of the Supreme Court judgment.
Listen, whether incorporation of your name in the tainted list is justified or not is not the issue to be decided, right? As long as your name remains in that list, the court is not in your favor. Now you approach any forum.
I made the representation before. Yes, my lord.
Before any forum. I am not specifying which forum. You choose your forum from where you can get your name.
I made a representation before the West Bengal Central School Service Commission. Yeah.
School Service Commission will not be in a position to do it because it is the CBI who has prepared the list.
But they have, that's why the CBI is a party.
Let the CBI remain as a party and the criminal investigation is pending.
Now, so the question, let the CBI bring the report. My lord, because of the fact, kindly come to paragraph 35 once of the Supreme Court judgment. Why I'm saying so much? The CBI report, because otherwise this will never be ended. Investigation, trial is going on. I personally went there. It's very chaotic situation, my lord. Kindly with this, but because the entire thing will be like this. Those have taken the money will not suffer anything, will come out. Those who have given money got the job, they will lose job. Those who have not given money got the job, they will also lose job. Both of them are suffering. 35, the CBI report dated 5/2/2024 notes the mismatch between the OMR sheet evaluation and the marks as recorded by West Bengal School Service Commission. So a CBI report was considered by the Honorable Supreme Court. The CBI report also refers to all email exchange between the staff of Messrs. Nicer regarding the increase of marks for specific candidates and the manipulation of data. The email, they said specific candidates. The email correspondence also shows that as a reward of the manipulation of OMR score, some of other works were awarded to such and such. Thereafter, my lord, kindly come to page 127, paragraph 38 and 39 will be reading. There is also a dichotomy in the positions taken by the tainted candidates and the untainted candidates regarding the scanned copies of the OMR sheets recovered from Pankaj Bansal and MS Data's Scantech Solutions. It is the stand of the tainted candidates before us that the scanned copy of the OMR sheets are not the ones which the candidates has filled up at the time of examination. Now, thus, they cannot be persecuted and treated as tainted. On the other hand, the untainted candidates claim that OMR copies sheets are original sheets which our candidates had filled up. 39, it is submitted that tainted candidates that the certificate under section 65B of the Evidence Act 1872 is inadmissible and thus the said data is unreliable. In addition to issues of the authenticity of the data, the mismatch between the data's sets and admissibility of the certificate under section 65B of the Evidence Act need not be decided in the present proceeding. Don't you hear the Supreme Court is saying the criminal court will decide. So now our status is that Supreme Court is also subjecting us to the outcome of this particular proceeding, criminal case. So unless I am decided, the intention of both the judgments were that who are specifically identified as tainted under those three categories, they will have to refund the money, they will suffer everything. They're out. But since I am subjected to this, that 65B, which is still now not admissible because unofficially
Listen,
by
the the Supreme Court has clearly mentioned no tainted candidate would be permitted to sit in the interview.
My lord, I say that I'm not
Please
a tainted.
approach. Your mere saying will not do. Your name is there in the tainted list.
But that list, the foundation of that list
Is under
is
challenge.
wrong, my lord. That's why, my lord, I want
Sorry,
to produce this chart sheet
No,
of the
sorry.
CBI,
Please
how the
come.
list have been given.
The petitioner's name features in the list of tainted candidates published by the commission, relying on the data received from the CBI. Is aggrieved by the same stuff. He prays for a direction upon the respondent authorities to
Well, for my satisfaction, Lordship, there is a demand justice which has to be, Lordship, kindly take note of that, also consider that.
to consider the petitioner as untainted candidate and to permit and to exclude his name from the list of the tainted candidates. Stop paragraph. It appears that the Honorable Supreme Court has clearly laid down that none of the tainted candidates shall be permitted to appear in the selection process to be conducted by the commission. Stop paragraph. The prayer of the petitioner for directing the commission to treat the petitioner as an untainted candidate and to remove his name from the list of tainted candidates cannot be allowed by this court. Stop. The Honorable Supreme Court was pleased to direct, pleased to hold that the parties ought to approach before the competent criminal court for relief. Stop. Next, in view of the above,
My lord,
the prayer of the petitioner
representation, my lord, kindly.
cannot be accepted. Stop. The writ petition fails and is hereby dismissed.
My lord, that
No.
liberty before the
No, no, no.
appropriate authority.
It will be open for it will be open for the petitioner to approach the competent forum for relief in accordance with law if so advised. Next is the same. Same order.
Preparing that. I'm appearing.
Let the affidavit of service be kept with it.
নামগুলো দিয়ে দিন
Item 5.
I am appearing for the state led by Mr. Shubhyojan.
Kindly give me 1 week time to file reply.
For filing?
For reply, affidavit in reply.
No, last week, not last week, 19th of January.
Yes, I have been served. I have given the copy also.
I am appearing on behalf of the school authorities.
All right. The petitioner took time on the last week also, so no further time. No. It's a matter of 2018. If you are not ready, then I'll dismiss.
I filed my affidavit in opposition.
Please. Yes.
এটাই করতে পারবে স্টেটেরটা দিয়ে দিয়ে
Give. Affidavit in
Both the
opposition
matters,
filed
5
by
and
the
6.
school.
Cool, Milord.
In court
On
today, we
30th
return with the
I have
record.
already served you a copy.
Tough.
Milord, on 30th August 2023, I was given liberty by
Please hand over, sir. It will be open for the petitioner to file reply to the same. Stop. Release the matter on 2nd of March 2025. Does anything survive? What?
No, my lord. They have with fake document, fake certificate.
They have joined service.
He joined. And second,
I got honorable acquittal there.
my lord, in the second writ petition, they have produced the certificate of another university, Mahatma Gandhi University. First one from Ranchi, second one totally fake.
All fake.
All fake.
All fake, and I got acquittal in the criminal proceeding.
How you obtain acquittal, it will be seen later on. ঠিক আছে. Seven.
Copy to serve করা আছে আপনাদের change
আরে ওরা ছিল না চেঞ্জ হয়ে গেছে দিয়ে দাও না
in this matter I'm for the school have the copy of the petition. I haven't received it yet. And secondly, your lordship, there are several other similar matters. This order has annexed. This should be tagged with this
Order from?
order from the this particular petition.
All the matters was assigned before the Honorable Justice Biswajit Basu when his lordship then. Regarding
All the matters. The one that petitioner is saying, the school is saying that also.
Lordship, kindly hear me for a moment. There were 5 matters. All the matters have been infructuous because I challenged the action of the school authority for appointing of teacher in charge, that has gone. I challenged the stopping of my salary, that has gone, petitioner retired. I challenged the one police inaction matters that has been decided.
What do you want now?
Now, my lord, arrear salary as well as the
terminal benefits.
And the gratuity is now, my lord, I have not received. Moreover, my lord, I am not getting pension due to pendency of this case, my lord.
All right.
This is my affidavit in exception, my lord. The report has been filed by the Mr. Samimul Bari appearing on behalf of the state, my lord.
All right.
I informed him. My lord, case is the petitioner is this, my lord.
You want to hand over?
Lord, petitioner, my lord, petitioner headmaster, my lord, was illegally kept away from the school by the then managing committee president of the school, my lord, for fulfill his private and personal grudge. And accordingly, my lord, in the year of 2015, when the managing committee was constituted, school was converted into sponsored institution, the president of the managing committee, Lord, filed a criminal case for misappropriation money of midday meal, ACR rooms, and others, my lord, before the Chief Judicial Magistrate Bakura. That has been quashed by this Honorable High Court. At first, your lordship kindly sees, my lord, my exception. Page, what was the complaint? Page, my lord, 8 onwards of my exception.
এই আমাকে দেননি তো এক্সেপশন
The one that you filed today?
Yes, that is the exception, my lord. In respect of report filed by the District Inspector of Schools.
Yes.
Page 8 of my exception, my lord. Onwards.
Yes.
Lordship got it?
Yes.
Get it?
Why you want to read all this?
This is, my lord, this allegation was against me that I misappropriate the money of midday meal from the school, also the additional classroom fund, my lord. That, my lord, case has been quashed by this Honorable High Court. That is, my lord, page
18.
Page 18 onwards. Lordship kindly sees.
Yes.
My lord, the relevant paragraph, my lord, page 23, paragraph 7. At that point of time, there was an administrator in the school. Got it?
Yes.
It is thus clear that during the period alleged, administrator appointed by the West Bengal Board of Secondary Education by letter number such and such, and the order of the Joint Secretary School Education Department dated such and such, prima facie show that the school was being run by administrator appointed by the said department, and the petitioner was no way concerned with the running of the school. And as such, the question of prima facie defalcation for the period alleged does not arise. Then, my lord, the vital, my lord, the relevant paragraph, my lord, page 28, paragraph 10 of the judgment, my lord.
Yes, I have seen.
The present case falls under clause 3 and 7 of para 102 of Bhajanlal Supra. Lordship kindly sees the para 7, page 28, where a criminal proceeding is manifestly attended with a malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking the vengeance of the accused and with a view to spite him due to private and personal grudge.
Yes.
Lord, thereafter, my lord, all the proceeding has been quashed. Then I was clear from the, my lord, the criminal case, my lord. Lordship kindly sees thereafter, I several times went to school to join, but my signature was penned through by the then president of the school. I made a representation before the school authority. DI, my lord, called for a hearing. President was not turned up. At the SP office, I attended the hearing, but president was not turned up. And this way, my lord, I retired in the year 20 January, my lord.
Which year?
2020.
2020.
16th August, my salary was stopped.
16th August of which year?
16th August of 2016, my salary was stopped. Lordship kindly sees the documents, my lord, of my affidavit in reply.
Retired when you say?
31st January 2020.
All right.
Lordship kindly sees the page 26 of my affidavit in reply.
Now, what is the stand of the state?
Lord, they filed a report.
Yes, what does the report say?
Yes.
Wait 1 minute, let him say.
Page 6 of my affidavit.
Let him say. Yes.
Affidavit.
Yes.
Page 6, my lord, detailed report of the DI.
Page 6.
Last 3 paragraphs of the first page, my lord, can you see? And thereafter next page.
The date of his retirement, he was absent.
More than 4 years.
From 2016, you were not permitted to join school. And you were directed to appear in interview, did not appear. You felt uneasy. You
At
expressed.
the inquiry, I appeared. I, my lord, as per the order.
You appeared and you felt uneasy.
Yes.
And you went home.
Due to the altercation, hot altercation, the president of the managing committee and some members of the committee heckled me, my lord, abused me with filthy languages. I admitted in the local nursing home. I made a representation before the authorities. I went
Now,
to
if
school.
you remain absent in school, then why will the salary be paid to you?
I was not absent. Lordship kindly sees my documents, my lords, and my affidavit in reply. 26 onwards, my lord, page. In my reply, Lordship kindly sees.
Yes.
Several times I went to school. Attendance register was taken away by the president. I made a representation to the president to allow me. Lordship kindly sees 26. Also, the district inspector of schools, I wrote a letter. 26, 27 onwards, my lord. Several days I went to school.
No, page 30 I can see. I went to the school and I felt senseless, and I became senseless.
Yes.
Because of my hypertension. Admitted to nursing home. That is in 2015.
That is in 2015, on the day of the altercation, my lord, the hot talk was on that day.
All right, that day it is over.
Then Lordship kindly sees the page 26 of my reply.
26 of your reply is the...
I wrote a letter to the district inspector of schools, and thereafter, my lord,
26 is the judgment of the court.
reply, my lord, affidavit in reply.
To the opposition.
There are two reply. One is exception, another is affidavit in reply. Lordship kindly sees.
Listen, you admittedly, for any reason, you were not there in school.
I went to school, but I was, you know, restrained to join.
You were restrained?
Yes.
Your signature is not there in the attendance register?
I put signature. That signature was penned through.
All right.
That I am annexed.
All right.
And I also made a representation to the president several times. That is page 27, 28, 29.
All right.
And also the 30 of my reply. I went to school, but there was no attendance register in my chamber.
Till your records are made in order, you cannot be issued any PPO. Right? Your pension file has to be made ready.
33 years of unblemished service, my lord. That is happened. I joined in the year 1983. Up to 2015, there was...
use making this submission because your pension file has to be made ready.
Yes.
Right?
May I submit one thing?
No.
But I'm for the school authority.
Yes.
Remember, there is a suppression of material facts.
All right.
Then,
The...
what materials, my lord?
No, please wait.
On the same self, lord, prayer, he has made a writ petition before Justice Sogota Bhattacharya, my lord. And lord, I have taken the point. The matter went up to the division bench, and division bench, blood, specifically directed to appear before the DI. But he did not till date. And on the other hand, he has shown, my lord, the criminal case has been quashed.
Yes.
Against that, my lord, the already matter pending before the Honorable Supreme Court.
What is that?
Yes, I will, my lord, if your lordship kindly allow me, my lord, not one matter. My lord, is there 7 or 8 matters, my lord, I will come before your lordship with the orders.
5 matters have been assigned, I can see.
Yes. That all matter has been infractuous.
4 2016 matter and 1 2022 matter. This is the 2022 matter.
And 10 matters or 11, or 10 months or 11 months before, he has filed an application which is pending before Justice Sogota and specifically directed him to come with the materials because he have suppressed the material facts.
Kindly see the district inspector of schools.
How many writ petitions were filed by you?
Not all the writ petitions have gone infractuous, my lord.
You file
That is observed by the Honorable
I will
Justice
come with
Biswajit
I will
Basu.
come
You
with that.
file a status report of all the writ petitions. Please come.
I'll come with that.
The petitioner is a retired teacher of a school. His allegation is that his terminal dues have not been released.
Only Provident Fund has been released.
Apart from the Provident Fund amount.
Yes, that has been released.
Stop. Paragraph. Learned advocate representing the school submits that the petitioner filed several writ petitions.
Even very recently, we are on the same self cause of action.
Achha, on the same cause of action. Many writ petitions are pending disposal. Stop. The aforesaid contention of the school is denied by the learned advocate for the petitioner. Stop paragraph. The petitioner is directed to file an affidavit disclosing the case numbers and the status of all the writ petitions filed by him in connection with his service.
And I will also come with the matter.
Stop.
With the same.
Well,
Such now let the affidavit be prepared and circulated within a period of 2 weeks.
A copy of the writ petition also, but I have not been. School
Sir, I have already served.
Stop.
This is my
I need-
I have filed affidavit of service. my
একটা
lord.
দেবে ফাইল দিয়ে
SLP number.
দিয়ে দেবো আজকে দেবো
Release the matter for further consideration on 2nd March 2026.
Well, kindly direct my learned senior friend to supply the SLP number. my lord. Otherwise,
yes, I will supply. I'll supply.
kindly direct me, lord.
Go
Kindly
to
record
the
it.
site and find it. He has disclosed it. You should know how these things are done. Affidavit of service filed in court is taken on record. Affidavit in reply filed by the petitioner to the exception. What did you file today?
So this is the exception, my lord.
To
In respect of the report filed by the district inspector of schools. Bankura.
exception to the report filed by the district inspector of schools.
I filed the affidavit.
আমাকে একটা কপি দেবে বাবু
Report not an affidavit
বাড়ি আমার একটা কপি দেবে
by the sub inspector of
পাইনি
schools.
পিটিশন
In court today be written with the records. এটা ফেরত যাবে স্কুলের
এই
কাছে.
যে রিট পিটিশনটা যেটা ফাইল করে
So kindly direct my learned friend to supply the SLP number. my lord.
Please give the number.
I have also
Did you file a
whether,
caveat?
whether it has been filed or not before.
Did you file a caveat? You did not.
So,
You should have. Call the next matter.
I have also paid for a copy of the rit petition from my
Acha 8.
Matter, I am for the
second
petition.
month.
Yes.
This is writ petition was mainly for the arrear salary with interest. During the pendency of the writ petition, salary has been paid. Arrear salary has been paid, which is evidence from the page number 8 of the supplementary affidavit. I have annexed the 9th February 2000.
Page number 8.
Yes, of supplementary affidavit.
Supplementary affidavit has 6 pages.
Page number 3. Paragraph 4.
6, last page, bank. 9th February 2024.
All right. So there is no grievance now.
Yes, sir.
Some,
Paid, my lord.
arrear salary.
Let me salary paid.
I am only
the
paying
interest.
interest. From the arrear salary remain due on 1st September 2007 to 30th September 2010, which is stated in paragraph 4 of the supplementary affidavit. That has
Please come.
paid on 9 February 2020.
The petitioner filed the instant writ petition praying for a direction upon the respondent authority to release his arrears salary for the period 1st September 2007 to 30th September 2010. Paragraph. During the pendency of the writ petition,
With interest.
comma, the arrears salary of the petitioner has been released on 9th February 2024. Stop. The petitioner prays for interest on account of the delayed payment of his salary. Stop. Paragraph. As the petitioner was entitled to receive his salary on the due date, but the same has been released after more than a decade, comma, accordingly, the petitioner would be entitled to interest on account of such delayed payment of his arrears salary. Stop. The instant writ petition stands disposed of by directing the district inspector of schools
Also added respondent treasury officer Jhargram.
and the
Added respondent treasury officer Jhargram.
treasury officer Jhargram. During that period, where were you, in Jhargram or in Howrah?
No, no, Howrah.
Last, he was at last retired from Jhargram.
Jhargram.
But treasury, but a pension account, as he is residing at Howrah, treasury at a pension account at Howrah.
I'll say Treasury Officer Jhargram and Howrah are directed to calculate interest on account of the delayed payment of the salary, arrear salary of the petitioner for the period mentioned herein above at the rate of 6% on and from the date the amount fell due till the date of actual payment. Stop. Such payment shall be released at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
My lord, one thing, in default, within period, my lord, additional.
Again, you have to come. In any case, you have to come.
Otherwise, I shall come before your lordship again, my lord.
You have to come. Next. Nine.
I for the petition led by Mr. Anjan Bhattacharya. The matter regarding for lordship, till date the petitioner did not get any arrear financial benefit.
Arrear financial benefit. What does this mean?
This means lordship kindly see the lordship page number 53 lordship. A similar order has been passed before this court lordship.
এর কোনো অর্ডার পাস হয়নি তুমি মানে এদের তো অ্যাপ্রুভাল দিয়ে দিয়েছে তারপরে এর যে আছে না এখানে কোনো অর্ডার পাস হয়নি কিছু অর্ডার পাস হয়েছে সেগুলো তিনি অ্যাপ্রুভাল দিতে বলে অর্ডার পাস হয়েছিল সেগুলো কম্পাইল করে অ্যাপ্রুভাল দিচ্ছে Answer for approval. One thing on the order. One petitioner, one of the petitioner.
Release the approved salary of the petitioner.
But here, lordship, petitioner did not wrote any letter to the DI. What salary has been due, what compliance has been not be done. Let the lordship demand justice has been given to the DI.
There is a demand justice.
No, there is no demand justice. So why? What
No,
happened?
what
The
we
DI.
One lordship the kindly.
What is your prayer?
My prayer is lordship the kindly
to approve the post facto approval of the petition on the date of the
after
initial
the order
appointment.
passed in my matters lordship.
Where is your matter?
Lordship kindly see the regarding kindly page 27. The petition number one order. The first time they come to the High Court lordship, the High Court considered my matter and sent to the DI to regularize my my approval lordship. My kindly see the paragraph third paragraph lordship.
Consider and dispose of the said representation on the basis of the lordship. Kindly see the lordship. I am coming, lordship. On the basis of the representation, lordship, DI pass your order, lordship. Kindly see the page 30. 30. 30 no? 30 lordship. Kindly see the page DI lordship. Appointment has been given lordship to the petitioner.
Approval.
It's to open the not teacher.
Approval. Approved.
It's open to no.
চারজন petitioner.
একটা দিন না একটা এই যে
First.
হ্যাঁ এটা here lordship 51 page 51 of the petitioner lordship DI approved lordship page 51 on the basis of justice Rashri Bharadwaj page 51
13th of October 2020 approved.
29th November 1919 lordship Bharadwaj the basis of the birth
and temporary service from 13th will be returned.
Thereafter, Lord, he is silent, Lord, DI, Lord, don't know about the what they demand. He wrote a letter to the Lordship, write a letter.
I cannot follow what your prayer is. What is your prayer? You want regularization or what you want?
Regularization are also kindly release my area lordship.
Area for which period?
Period lordship, my appointment is lordship, kindly see.
Your appointment is from 13th of
My appointment is 1989 lordship.
89. Your approval is from 13th of October.
Lordship. The DI considered my approval 2070. This is the wrong lordship. That's why I have considered continue my 69 lordship. 89.
89 কি বলছে?
89.
না না 99 সাথে কিন্তু
You are not prepared in the matter. You are not at all prepared in the matter.
Lordship,
I can see your approval from 13th of October 2020. 13th October 2020, Bhavani Saran Srivastav. How many petitioners are there? Four.
No, four.
Four petitioners. Where are the approval letters of four of petitioners?
Lordship, here kindly page 30, Lordship, one of the petitioner 30.
Yes.
One in the Upendra Nath Rai.
Yes.
And Lordship, second one is Lordship 51.
That is petition.
Yes.
So Saran Srivastava is the petitioner. And third one
So
is the
two.
two, only two.
Two of the petitioners approved from 2017, the rest from 2020, and you are seeking from 1989. How?
Because lordship, my appointment letter is issued by 1989 lordship.
90?
89.
So what?
Your appointment. Without approval.
Lordship.
Please come. The petitioners, comma, four in number, comma, have filed the instant writ petition praying for a direction upon the District Inspector of Schools to approve post facto approval to them from their initial appointment in the school. Stop. The petitioners claim that they were engaged long prior to their date of approval. Stop. Prayer has been made. No, prayer dite hobe na. It appears from records that the service of the petitioners stood approved on diverse dates in the year 2017 and 2020. Stop. Next. There is nothing on record to suggest that the petitioners approached before the competent authority seeking post facto approval. Stop. Without supporting documents, comma, it is not possible for the writ court to pass order upon the respondent authorities directing post facto approval of the service of the petitioners. Stop. In view of the above, no relief can be granted to the petitioners in the instant case.
Kindly send the matter to the DI to
The
consider lordship.
writ petition fails and is hereby dismissed. Affidavit of service filed in court is taken on record.
ওটাই তো বললাম ওটা না lordship, this is only one prayer. Kindly send the matter to DI to consider only. If lordship did not.
Under what will the matter be sent? There is nothing on record.
Why lordship? Because if the matter is dismissed lordship, the DI never entertain my repentance lordship. If lordship direct the DI to consider the entertain my repentance, then the
Why will the DI entertain your writ petition? The writ petition is to be entertained by a writ court.
obvious it's a the right thing, but lordship kindly only one line added in this order lordship. If they go to the DI office, so then they only have a entertain, and I submit all the paper in the DI lordship.
What, you have not submitted any paper in the writ court? Then what can be done? Are you there in this matter? I have dismissed the writ petition because there is nothing on record. Nothing doing. What? There is nothing on record.
Nothing on recruitment.
DI का मुझे कोनो representation नहीं
No,
तो दिए.
before the DI, my lord, I have not made any
So,
representation.
what
Then
this is
what
the-
will the court?
Kindly grant me that liberty.
The matter is pending from 2023 in 2026.
For the first time, it was heard. It has been heard.
Just imagine the position from 23.
But
You got approval in 2017.
well, I was discharging my duty.
First of all, why have 4 petitioners joined in one petition? I do not know. All diverse dates. The approval, the initial appointment, all of diverse dates. The approval, diverse dates. How come they come under the same writ petition? No explanation. No, you cannot explain. Only by merely paying the additional court fees will not suffice. There has to be
May I
some
answer?
reason as to why they will come
May I
together.
answer to this?
Maybe of the same school.
Yes.
Nothing more than that. That cannot be a reason.
May I?
And from 17, you did not make any representation. In 26, you want leave from the court to file representation.
May I only?
Yes.
Well, the writ petitioners before your lordship, well, they were teachers, well, who had not been approved by the district inspector. Well, has seen. Now, by the orders of this court, by various orders of this court, well, the approval has been given. Kindly, well, have a look to the approval order
I am
page.
not going to look to the papers again.
No,
Yes.
only kindly give me 1 minute time so that
Yes.
I can satisfy your lordship. Page 51, 52, these are the orders by which I have been approved. My approval was made in 2021, post facto approval. Thereafter, this judgment of page 53, it has come in 2022. In another case, where the similar benefit has been given, that from the initial date of appointment, he has to be given all the benefits. Thereafter, the judgment of Justice Mantha, page 61, it has come also in June 22, where Justice Mantha has supported the judgment of Justice Krishna Rao. Now, what has happened is these petitioners were there in the school discharging their duty. Now, I filed this petition in 2023 after I retired. We seek
after your retirement, you file a writ petition for grant of post facto approval from the date of your.
Yes, that is the order. That is the judgment of Justice Krishna Rao. Kindly, have a look to the judgment.
I have checked up the judgment. The prayer for regularization was disallowed, and there was only a direction for consideration.
Yes.
But in your case, there is nothing to consider. You have never approached the authorities.
Your lordship, kindly have a look to Justice Krishna Rao's judgment once.
No, sir.
My junior may not apprise your lordship correctly. May I?
I have read it.
May I for 1 minute?
Mr. Bosha was there, and it has been pointed out that there is nothing.
For 1 minute, for my satisfaction, if your lordship kindly grant me.
No, 1 minute is long over. See,
only
cannot be.
Kindly grant me leave so that I can approach the DI to.
After you retire. আচ্ছা আরেকটা লাইন লিখে নিন তো prayer has been made to allow the petitioners to approach the district inspector of schools with prayer for grant of post facto approval to their service on and from their initial date of joining. All 4 have retired.
Yes. Everybody's.
Acha paragraph. It appears that 4 persons have joined in to file the instant writ petition stuff. It appears that the petitioners were appointed on diverse dates and their approval were also given on different dates. Stuff. Merely because of the reason of them serving in the same school does not allow the petitioners is not a ground for joining together to file one writ petition. Stop. The cause of action in respect of 4 petitioners are completely different, and 4 separate writ petitions ought to have been filed. Stop. As regards the prayer seeking leave to file representation, the same cannot be allowed in view of the fact that all the 4 petitioners have retired from service. Stop. after such a long period of time, comma, the allowing the petitioners liberty to approach the district inspector of schools for according approval to their service from the initial date of appointment. From the initial date of appointment may not be proper. Stuff. Next. এবারে উপরে in view of the above, the writ petition fails and is hereby dismissed. Next.
No liberty.
10.
Paying for some time, to file the exception to the report. Some time, my lord.
I am dismissing the writ petition.
It is ready, my lord, because the petition.
Last time in January, you made the same prayer. In February also, you'll make the same prayer. Why will the writ petition remain pending?
2 or 3 days.
No, 3 days. You tell me what the matter is.
It is ready, my lord.
You tell me what the matter is. What is your prayer?
19.
Page 19. What is the prayer? Fresh consideration of petitioner representation allow her to participate in the verification process in connection with first SLST 2016 upper primary. What is the stage? The panel has expired.
Yes.
What is the stage? How can order be passed?
This report has been filed by them, my lord. I have to file, my lord. One chance.
No, nothing doing. Please
Last
come.
chance, my lord.
Sorry. Please come.
Kindly see page 40. The candidate was rejected in 2021.
The learned advocate representing the petitioner seeks further extension of time for filing the exception to the report filed by the commission. Stop. It appears that the petitioner has prayed for a direction upon the respondents to set aside and quash the impugned rejection dated 17th. Now, rejection date dite hobe na, passed in August 2021. Stop. Further prayer has been made to allow her to participate in verification and interview process in connection with first SLST 2016 bracket open upper primary. Stop. Paragraph. It appears that the panel from which appointments are being given expired long back. Stuff. At this stage, there is hardly any scope to allow the prayer of the petitioner, permitting her to participate in the verification and interview process. Stuff. The selection process of first SLST 2016 within bracket upper primary is long over. Stuff. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Next.
With the statement, I'm for the school authority, my lord. Filed one report. Madam, kindly consider pursuant to your lordship's last order, 14 January 2026.
To file, if petitioner do not file, then
আমাকে একটু বলি। 14 January 2026, your lordship was pleased to permit the petitioner to file an exception to the report. But I have also gone, I'm the school authority, gone through the report. There are certain allegations against the school, but kindly allow me to file my exception.
It is not your writ petition.
No, not my writ.
Then,
but the
if you are aggrieved, you file fresh writ petition.
but, allegation is there against me in
Doesn't
the
matter.
exception. But
No, sorry. Now, what is your prayer? There is a microphone, sir. Please use it.
Approval of appointment has been done.
Approval of appointment. Yes.
Salary has not been released. Certain period
Why?
salary has been released.
Why has it not been released?
The certain allegation has been made by the district
Yes.
inspector. Also filed the report. Lordship, I am paying for lordship.
What is the allegation against him?
allegation, my lord, petitioner without any, my lord, selection process,
my lord, appointed as third group D post, though there is no sanction memo. Earlier, DI, my lord, gave my lord approval against that, my lord, illegality. The one member of the my lord, Christian minority school, one member filed a complaint. And it was found that 8 appointments, all are, my lord, the bribe has been taken, and DI already, he was in, my lord, judicial custody, my lord, for long time. My lord, thereafter, my lord, district inspector school prepared one report and submitted to the, my lord, the principal secretary, stating all appointment, including the, my lord, the petitioner, who, without any approval, without any, my lord, selection process, appointed as third group D,
Yes.
as per rule.
So what have you done? You've set aside his appointment?
That was not, the approval was not taken up.
Everything is, my lord, lying with the, my lord, principal secretary for taking this, and not only his appointment, all appointment, because he do not have any appointment.
What happened? Has the principal secretary taken a decision?
No, my lord, kindly have a look into my.
But that's why, my lord, kindly allow
Where
to
is
file
it?
exception.
Allow me, Lordship, only for exception, Lordship.
43 of?
43 of my report.
All right.
My lord. Report take finger.
Yes.
My lord, kindly come to 43.
Yes.
My lord, information in respect of illegal activities regarding appointment of teaching, non-teaching staff of Vimpur ABM Girls School. It's a Christian minority school, my lord. My lord, kindly come to next page, 4. Serial number 4. Again, that salary of Onuron Sheikh petitioner has been drawn August 23 to January 24, such and such, misusing the user ID and password of portal after payment of salary till January 2024. Her employee profile, his employee profile in salary portal of such as has been withdrawn by the school authority as per video memo dated School Education Department. 1 Group C and 2 Group D are eligible to work.
The DI has forwarded this to the principal secretary.
Yes.
This is merely an information.
Yes.
But what steps have the DI taken against these people? Criminal case is pending.
They left out the school. Criminal case is pending.
They are not in school now?
No.
They have left the school.
August 2024 to till date, he left out the school.
Left out means what?
He did not work.
No, my lord, he is working, my lord. That's why I paid you also. Kindly allow me to file an exception to the report, because I have to depose.
Supporting, my lord, because
Yes,
the
but
managing
school.
committee, one managing committee raised objection against illegal appointment. My lord, at present managing committee, they are supporting.
I will show you also the details, my lord. Kindly allow me to file my exception. Because
nothing,
because
Lordship.
this is a Christian missionary
Working in the school, Lordship.
Without following any procedure, my lord, the appointment has been
This
given.
is Christian missionary school is run by 74 and
1974.
Seeks for a
prerogative
direction
of the school authority to issue appointment.
upon the District Inspector of Schools, Paschim Mednipur, seeking release of his monthly salary on and from the month of February 2024. Stuff. Next. The District Inspector of Schools has filed a report before this court, wherefrom it appears that the DI has intimated the Principal Secretary School Education Department regarding the illegal activities in respect of appointment of teaching and non-teaching staff in a Christian minority school. Stop. There, no, according to the DI, there has been misuse of government fund. Stop. Paragraph. The DI asserts that the petitioner is not rendering service in the school. Stop. The aforesaid submission of the District Inspector of Schools is denied by the learned advocate representing the school authority. Stop. The fact whether a criminal case is reported to be pending.
Page 30. I have just Charge sheet. Page 30.
That was before the appointment of the petitioner.
Is it anyway related to the petitioner?
No, this FIR was lodged before appointment of the
Supplementary charge sheet page 35, 35 and 36, my lord.
Yes.
36.
36.
Supplementary charge sheet, Clark Onuron Sheikh, Group D, and such, without the knowledge of his office. He also reported that the name of such and such is found because selection and everything was
Pending
done
consideration.
without
Yes,
approval of the
paragraph.
district school.
Consideration. With charge sheet filed. Stop paragraph. The court is of the opinion that there are disputed questions of facts which cannot be decided by the writ court. Stop. As the district inspector of schools has already drawn the attention of the principal secretary in this regard, accordingly, the instant writ petition stands disposed of, directing the principal secretary, school education department, to look into the matter and find a solution to the problem that has cropped up. Stop. An opportunity of hearing shall be granted to the petitioner, the school authority, and the representative of the district inspector of schools for arriving at a proper decision in the matter. The principal secretary shall take steps at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed by the principal secretary and communicated to all parties immediately thereafter. Writ petition disposed.
Good.
Next. Actor line add up for it is made clear that all points are left open to be decided by the principal secretary upon giving hearing to the parties. Yes, 11 and 12.
Okay, perfect.
Yes, petitioner.
And for the human led by himself.
And for secondary board, your lordship.
Application for a direction upon the board, my lord, for changing of name, your lordship remembers. Shubhajit Jagannath Mishra to Shubhajit Mishra.
No, Shubhajit Mishra.
But I produced two judgments, my lord. Your lordship asked them to file a report, and I was asked to file an exception. It is an exception.
Yes. Has your prayer been allowed or considered? It has not been considered. Is it pending?
No, it has been disposed of.
It has been rejected.
No, my lord, not rejected, your lordship. My lord, the order of the board at page 42. It is not rejected, my lord. Board have said that
I have to obtain a birth certificate.
The board is not the competent authority to change the name and or identity of a person giving retrospective effect. Board can only change the name if the name is changed in the birth certificate. On receipt of the matter, we will function on this.
Did you get a changed birth certificate?
I got a PAN card change. I got my Aadhaar card change.
Relying on which? Relying on which?
I applied.
Which document?
Of India notification that has been changed also. Even the magistrate's affidavit is there. First class magistrate's affidavit is there. Everything I have is the new name. Now the problem would be I cannot file the return even. Even I can't have the salary. That is the predicament, my lord. So on the basis of this, my lord, I showed one judgment before your lordship.
Show the authority of the board to do it in the absence of a birth certificate.
All the directions were the similar matters, my lord, directions were passed against the board, correct. And this is my fundamental right, my lord. The board's administrative decisions cannot override the fundamental rights.
What is your fundamental right to change your name in the midst of your service career?
After 26 years of passing Madhyamik examination.
And yes.
I have applied, my lord.
Yes.
I have applied. It is not that I'm sitting. I joined.
No, you may have applied in 2018, but you were born long back with a different name. The change of name changes the identity of the person.
When I have a minor, my lord, I cannot change.
You never thought of changing. Even after you attained majority, you got your job in that name.
I understand.
Then
But my lord, one thing, my lord.
Show me that there is some.
These are, my lord, subject to correction, my lord. Subject to correction. These are public documents, my lord. There's a presumptive value of public documents, my lord, as per Evidence Act, my lord. So correctness, presumption of correctness, as per Evidence Act, my lord. These documents are correct documents.
The board is not saying that you are relying upon incorrect documents. The board did not say so. Board
is asking for another document.
You produce that document and get it done. Did you apply for a birth certificate?
How can
Why
we
not?
keep birth certificate?
That was in the old days.
That when you were born, you got your birth certificate. But for the change, you did not apply.
Sir, একবার না
No, you didn't.
স্যার একবার একটু এই জাজমেন্টটা যদি জজ সাহেব দেখেন ওই জম্মু কাশ্মীর
দেখিয়েছি আমি জজ স্যারকে আমি
টু সাজেস্ট এই যে এখান থেকে
My lord, may I read one paragraph of the judgment, my lord?
Muhammad Hassan.
Yes.
Paragraphs 14 and 19 you relied upon?
19 and 20, my lord.
18 থেকে একবার
Should I read, my lord?
Tell me, I can read it myself also.
My lord, paragraph 18, my lord, borrow.
Yes. From the perusal of the, it begins that normally no change is permissible. Normally, no change is permissible. Where it is warranted, the change may be permitted. Chairman power to correct correction in the spelling, right?
Yes.
And then computing error, the explanation of that. What are the type of mistakes?
Paragraph 19, your lord.
One is correction of mistake in the existing particulars, which can be permitted if it is transcriptional typography. Second, change is registered other than correction. These would include change in name, change in parentage, such and such, However, this change only in cases it is warranted. Normal is that no change in. So it goes against you.
Paragraph 19, my lord, your lordship.
Since right to adopt or change name has been declared as a fundamental right, has been interpreted so that it does not infringe the fundamental right of anyone who seeks to change his name. A restriction in frequent changes may be read into efforts, but it cannot be interpreted so that to put a blanket ban on change of name on particular. What interpreted? The correction committee is definitely vested with the power to permit change, parentage, and other things. All right. Thus, the ground for request is beyond the mandate of the correction of is not legally sustainable. Yes. Firstly, the board doesn't have a correction committee over here in this case, right? Now, if you want a correction, that is because of you voluntarily chose a different name, not that it was an error on their part. It is absolutely on you. So, for a change, you require supporting documents. The board wants a birth certificate with a change name.
Your lordship, observe that. I'll do that.
Please come. The petitioner is aggrieved by the direction upon aggrieved by the communication made on 13th August 3rd August 2022, requiring the petitioner to produce a birth certificate issued in his changed name for correction of his certificate issued by the West Bengal Board of Secondary Education in his class 10 examination.
1994.
Achha. The petitioner passed his board examination in the year 1994 with the name Jagannath Mitra. Stop. He intends to change his name from Jagannath to Shubhajit.
In 2020.
Stop. He applied. Now he published a gazette notification with his changed name in January 2020. And he prays for a direction upon the board to change his name in the in his educational certificate, relying on such gazette notification. Stop. The board has refused to accept the prayer of the petitioner and has sought for a birth certificate in his changed name. Stop. The petitioner is aggrieved by the same. Stop. Reliance has been placed on the judgment delivered by the High Court of Jammu and Kashmir and Ladakh on 11 September 2025 in WP within bracket C number 21 of 2025
It's 2025.
in the matter of Muhammad Hassan versus UT of J and K and others, reported in 2025 SCC Online J and K 937. Paragraphs 14, 18 and 19 in particular. Stop. It has been stressed that the court held that change of name, right to change the name, has been declared as a fundamental right, and accordingly the board ought to permit the petitioner to change his name. Stop. Paragraph. The aforesaid submission of the petitioner is opposed by the learned advocate representing the respondents. Stop. Learned advocate representing the board submits that the change can be made only if the petitioner provides a birth certificate with his changed name. Stop. Paragraph. In Muhammad Hassan within bracket Supra, the court in no uncertain terms held that normally no change in name, parentage, date of birth and other particulars registered with the board is permissible. Stop. However, transcriptional or typographical errors may be corrected. Stop. Where change in the registered particulars, other than correction of typographical errors is sought, the same is permissible only in case it is warranted. Stop. In the instant case, the petitioner submits that he has already made the necessary changes in his PAN card and Aadhaar card.
Voter card.
And PAN, and voter card. Stop. He will not get his salary. No, as he is an employee of the school, he will not get his salary.
Nor can I file return also.
And can not file his income tax return if his changed name is not incorporated in the official records of the board. Stop. Paragraph. Upon hearing the submission made on behalf of all the parties, it appears that the board has not rejected the prayer of the petitioner for change of his name. Stop. The board has sought for a supporting document relying on which the change may be effected. Stop. It will be open for the petitioner to obtain a birth certificate in his changed name for making the necessary changes in his service records and in the records maintained by the West Bengal Board of Secondary Education. Heat petition stands disposed of. Exception to the report. Exception by the petitioner to the report filed by the board be written with the record.
Madam, I am acting on behalf of the school authority.
Last question, your
Oh,
lordship.
CC.
Please to give me highlight 4.
Yes.
And my lord, the exception be kept on record. What I was suggesting, after going through the entire scenario, the exception report, matter dispute relating to CCL of 45 days. I was talking with my learned friend whether the High Court should interfere to invoke the jurisdiction of Article 26. Can it be sorted out?
You sort out between yourselves.
That's why both of us
Huh?
agreeable. It can be sorted out.
Hmm.
We should make an application before the managing committee. Managing committee will
We'll consider. Please come.
No, your lordship kindly. This is the don't record it. Your lordship adjourn the matter.
I'll dispose it off. Why keep it
No.
pending?
If he is not
আচ্ছা ঠিক আছে
keep
the
it in monthly list of March
report
or any day subject to your lordship March in the month of March. I believe
by the report in the form of affidavit by the school and the exception thereto by the petitioner filed in court today be written with the records. Stop. The matter relates to grant of childcare leave. Stop. The petitioner seeks time to approach the school authority with her prayer. Stop. In the event the petitioner approaches the school, the school managing committee shall consider the prayer of the petitioner in accordance with law. Stop. Let the decision of the school authority be placed before this court on the adjourned date, list on 6th of April 2026.
After
6th April.
Oh, 6th of April. 6th of April.
থাকবেন না
ফুটে থাকবে
ও
for the petitioner. Well, this is
For
this
this matter, I am late by comment period, my lord.
higher scale of pay. Well, this issue has been settled by the judgment of the Honorable Special Bench, my lord. This is my affidavit of service. I served, my lord. They are appearing here, my lord.
Where, at which stage is it pending?
Yes, my lord. It has been kindly come to the impugned order itself, page 40 of the writ petition.
Yes.
Well, this issue has been categorically settled by the. My lord, kindly take the second page. 2 dates are important. The school authority resubmitted the prayer along with necessary documents on 26th of April 2019 regarding postgraduate scale of pay of Soumitra Pal, assistant teacher. As per resubmission of the school authority, Soumitra Pal joined first.
Is it your case that Tarak Karan has decided this issue?
Yes.
Are you aware?
I just say, my lord, I just indicate before joining, I got myself enrolled in the master's degree course. So there was no scope for me to obtain prior permission. Date was 1st of March 2011. I got appointed.
Are you accepting the stand of the petitioner that Tarak
Yes,
Karan
my lord. After this special bench judgment, the assistant secretary to the department circulated common circular to the all DI in inviting reference to the subject noted above, and in view of the order, honorable such and such, the undersigned is directed to request him to take decision with respect of grant of higher scale of pay in terms of judgment of the Utpal Kanti Karan versus such and such. The undersigned is further directed to state that.
Would you like to revisit the issue?
Well,
Yes, my
I can show
your
you.
lordship
My lord, may I just-
send the matter to the DI. DI will pass the fresh order.
My lord, I can show
And
you
my lord,
this one
considering
substantive-
this
Utpal Kanti Karan.
honorable court, other coordinate bench also passed the order very recent.
My lord, may I show you Utpal Kanti Karan and kindly see? My lord,
Yes.
this is categorically covered by Utpal Kanti Karan. May I just show this?
No, it's all right.
My lord, kindly
Please come.
appreciate. My lord, kindly
The-
let it be set aside, and my lord, it will be given to me.
And my lord,
My lord, because kindly see, my
The
lord,
order
this
dated
paragraph G, my lord,
22nd
show
of
Utpal Kanti Karan.
July 2019.
My lord, may I show Utpal Kanti Karan for one?
Passed by the District Inspector of Schools, Secondary Education, Kolkata, rejecting the petitioner's prayer for grant of postgraduate scale of pay is impugned in the instant writ petition. Stop. It has been submitted by the petitioner that as the petitioner joined the postgraduate course prior to his appointment, there was no scope on his part to obtain prior permission. Stop.
And my lord, I'm entitled from the last date of examination. That is
According to the petitioner, he is entitled to the higher scale of pay on and from the next date of completion of the postgraduate examination. Stop. The petitioner relies on the judgment delivered by the special bench of this court in the matter of Utpal Kanti Karan versus the state of West Bengal and others, reported in
my lord, I can give the number.
আচ্ছা রিপোর্টেরটা আমাদের কাছে লেখা আছে একটু দেখে নেবেন তো হ্যাঁ
APO
WPA
number 303 of 202.
no special bench has delivered judgment.
Special bench.
This is my lord APO 343 of 20
আচ্ছা next
with
prayer has been made to direct the district inspector of schools to grant higher scale of pay to the petitioner upon setting aside the impugned communication.
along with the area, my lord.
Stop. Learned advocate representing the state submits that the assistant secretary, school education department, law branch has circulated instruction to all the district inspector of schools to take decision in respect of the issue of grant of higher scale of pay relying on the judgment delivered by the court in the matter of Utpal Kanti Karan. Within brackets, supra paragraph. As it appears that the respondent authorities are agreeable to revisit the issue, accordingly, the impugned rejection dated 22nd July 2019 stands set aside. Stop. The District Inspector of Schools, Secondary Education, Kolkata is directed to revisit the issue of the prayer of the petitioner for grant of higher scale of pay, strictly in accordance with the law laid down in the matter of Utpal Kanti Karan within brackets supra. After giving reasonable opportunity of hearing to all the necessary parties, at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Fresh reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps for releasing higher pay scale shall be taken without any further delay.
Along with area, my lord. Not kindly.
From on and from the date of your entitlement?
No, from the area, because I cannot raise this point subsequently. I'll be covered.
On and from the date of his entitlement, which means your areas.
That may be recorded, my lord.
What will be recorded?
That from the date of, that is my.
For entitlement?
Yes.
What does area mean? That means from the date of your entitlement.
Directed that, my lord. Then let it be recorded.
On and from the date of your entitlement.
Very much. Well, this entitlement, they will raise an issue that you are not entitled from that date or this date. No. Kindly records it, my lord.
Or record what?
That from the last date of examination, the area.
Let the court record
the
that.
area, at least the area
Let
part.
the entitlement be decided.
Again, my lord, I have to come before your lordship.
Decision. You will come. If you are to come, you will come.
My lord, may I give the number of Utpal Kanti Karan?
No, I have
Citation.
it. I have it.
Very well, my lord. It is Didi, ছবি তুলে দিয়ে দিছো দাদাকে?
15 Lordship, I beg to appear on behalf of the petitioner.
On behalf of the state, my lord.
Lordship was kind enough on the last occasion to direct us to implead managing committee. Accordingly, we have done it. My lord, and my lord, we have sent a copy, my lord, addressed to them. Though, my lord, that is yet to reach. But president, my lord, is being
whom?
Managing committee. Addressed to president, and my lord, president is appearing over here. And myself is secretary of the committee of the managing committee. All of are here, my lord. Formality has been observed and that was sent, my lord, that being the situation. My lord, here my
has not been received. It has not been.
Well, the president is represented by my lord, by letter.
But why don't you hand over a copy to him to get things done?
My lord, the same copy which we have already handed over, my lord, my learned senior is appearing since then, my lord. Same copy, my lord. What is the utility, my lord?
What is appearing for this
president?
Allegation in
no, let you place his case. I'll hear you thereafter. But then,
So,
if you are
no,
ready,
no.
then I can proceed.
I was not made a party.
Now you have been made a party.
Court granted to make them party. Thereafter, I
Alright, now,
appeared.
Yes.
Now, my lord, the managing committee as a whole was not made a party. I raised an objection. The writ petition
The managing committee has been made a party.
party, but the copy of the managing committee has
You
not.
have a copy already.
Managing committee president is not alone. If your lordship are like, I am appearing on behalf of the president, no problem. The
Yes.
managing committee, what is the rules? After receiving the
Let the petitioner place his case. Yes.
But it's a case, my lord, we are praying before the appropriate authority to appoint an administrator. As to why, my lord.
Before my learned friend starts, I tell you one preliminary objection. Thereafter on the merit. My lord, one member of the managing committee cannot maintain the writ petitions. He is the member of the managing committee, being a secretary or headmaster, whatever. He cannot maintain the writ petition.
All right. But it's
Now,
my duty.
if the writ petition is filed, then my lord, majority member is required to be take a decision by them.
And the stalemate will go on, my lord. I am a headmaster of a particular school. It is my duty to run the school to, my lord, provide, my lord, the square meal. So far, my lord, the
Who's
students
from
are
the
concerned.
state? Let me see your report once. Is the state aware of all the happenings of this school?
Before that, only one document may kindly be looked into, my lord.
My lord, may I?
Page
My lord?
46. They have requested, my lord, the president to extend all sorts of cooperation. My lord, the teachers who are superannuated, they are not.
My lord, the DI, my lord, the DI has requested
If
the
I say
board
something against
to look into the matter because this impasse going on in the school. Basically, there is a fight between the president and the managing committee members, teachers, and the headmaster in the other side. That is the main thing.
Only one
So, my lord, board has instituted a committee. It has visited. It have gone through it. And a report, my lord, this is the report which are the.
What does the report say?
Says, my lord, lot of anomalies on the part of headmaster, on the part of president.
That's why
President, no audit, nothing. There are a lot of
What is to be done?
So, Mala, they have directed both of them to cooperate with each other and do the work accordingly, get the things audited, and some routine has not been, the regular routine of the classes has not been done properly, which has to be done, and all thing has to be done. And Mala, there is one line, the headmaster is directed to act in accordance, otherwise proceeding will be initiated against him.
Well, we are ready and willing to face the proceedings. But at the same time,
there are some teachers of
President, my lord,
all the allegations are against the headmaster.
Let me, my lord, let me allow, my lord, to show some document and then, my lord, kindly take a decision. My lord, kindly come to page 46.
On a whim of a
headmaster of the managing committee.
Kindly see, my lord,
that's the main thing.
46 may kindly be looked into.
Willing to
Kindly see, my lord, page 46.
Before the court for supersession of the managing committee.
The headmaster of a school has approached the court
it cannot be.
by filing the instant writ petition alleging illegal activities of the
No, my lord, not attending, my lord, meeting, as a result of which the school
Very
is
well.
not in a position to pay, my lord, the superannuated.
According to the headmaster, the members of the managing committee are not attending the meeting.
About
for
2 years.
which decision, for which the normal functioning of the school is being hampered. Stop. The submission of the petitioner is opposed by the learned advocate representing the school managing committee and its president.
The headmaster is not cooperating.
Stop. It is the submission that the headmaster is not cooperating with the school managing committee. Stop. It has the issue of maintainability of the writ petition at the instance of the headmaster, challenging the act of the managing committee, has been raised by the learned counsel representing the school. Stop. Paragraph. Learned at the
2 pages may
District
kindly be.
Inspector of Schools within bracket Secondary Education Purva Mednipur has forwarded a report signed on 16th of January 2026. It appears therefrom that the DI has already reported to the West Bengal Board of Secondary Education. Stop. Learned advocate representing the board relies on the communication made by the Deputy Secretary within bracket Disciplinary Authority of the board addressed to the president and the headmaster of the school.
Last para may kindly be looked into of that report.
Vide memo dated 20th January 2026. Stop. It appears that the Deputy Secretary has issued several directions both upon the headmaster and the president of the school. Stop. Paragraph. Upon hearing the submission made on behalf of all the parties, it appears that there is an infighting between the headmaster and the school managing committee. Stop. The not the due to the due to the acrimonious relationship between the parties, comma, the normal and regular functioning of the school is being jeopardized. Stop. The board has already taken the matter into consideration and issued several directions. Stop. The parties would be bound to take steps in terms of the directives issued by the board. Stop. The writ petition stands disposed of.
No, my lord, direction may kindly be given, my lord, to my lord, the invitation of meeting, my lord, summoning meeting is to be
Made
attended.
clear that the court has not considered the issue of maintainability of the writ petition, and the writ petition is being disposed of relying on the directions already taken by the board to resolve the dispute.
Only difficulty, my lord,
Take
last
this
2 years
back,
there is
whoever
no
has
meeting.
issued.
Last 2 years there is no meeting, my lord, the stalemate is still there. That being the situation.
Yes, next.
Get.
না ওটা আমার।
Develop.
আরেকটা দেখো
এই তো judgment.
না ওইটা আমার একটা কাগজ আছে এই আমার একটা
এইটা একটা
Pending before the division bench. Delisted pending before the division bench.
16 to 20 is similar.
16 to 20, it will be called one by one and order will be passed. Let me see if state council is there. Delisted. 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 Delisted.
I am for the state, my lord.
Give your appearance, please. Delisted. Yes, please.
That matter, my lord, whether the petition is.
It appears that the issue is decided.
No, my lord. This matter, my lord, whether already decided, the SAT, before the single bench or division bench.
13th of January 26. I have a copy of the order.
Yes, my lord, already decided, my lord. That
Where is the state?
Learned advocate.
The state.
Learned advocate. In this matter, my lord, affidavit is required, my lord.
Yes, all right. Please come.
Learned advocate general appears.
Issue as to whether the instant writ petition will be maintainable before this court or not has been decided by a coordinate bench of this court on 13th January 2026 in WPA such and such, Muhammad Masidul Islam versus State of West Bengal and others. ঠিক আছে? Stop. The court was of the opinion that as the tribunal is not functioning, comma, the writ petition is found to be maintainable before the writ court. Stop. Paragraph. Accordingly, the issue of maintainability of the writ petition as raised by the respondents cannot be accepted. Stop. Paragraph. The respondents are directed to file affidavit in opposition within a period of 6 weeks, reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. This is the judgment.
May I break one thing? Any
if you would
And mention and then come.
But leadership, my apologies for having late. I was running down the corridor. Probably
This issue has been decided.
Yes, but we have a second point on maintainability also.
What is the second point? This was the only point raised by the AG.
The first,
Whatever the second point is in your opposition.
so
Let
kindly,
the writ petition be
kindly
made.
let
I have
that be
given you.
kept open to be dealt with in affidavit.
No, nothing is kept open. Whether it will be before the tribunal or not, this issue has been decided and the court has recorded that. All other issues in your opposition you can take.
But that
That
issue
you can
includes
take.
another point, because his writ petition can lie only against a personal, my lord, cause. Here, my lord,
That is the merit of the matter. You take
very
your
well,
point in opposition.
I'll take.
Take your point in opposition.
I'll take.
Yes, next.
My any date or
No, date I do not think it will be possible. Hearing matter, it will take time. You have to wait. And you can check up benches. See, I am filled up with motions.
challenge it because of that one. That government school teacher transferred to PRGF school. That's the reason, my lord.
All right.
May I-
Let the opposition be over, then I'll
May I just only indicate, my lord, as far as I have been informed, my lord, from my learned brother, that your ladyship has said that the maintainability point has now been settled.
settle with regard to the issue of tribunal or the high court.
Only that.
Yes, I've quoted that line also.
My apologies. I'll take my
That
points.
it is the tribunal, it is a writ court which will decide it.
Very well. Grateful.
Yes, ma'am.
Next, 22.
I don't know.
22, is anybody appearing? Where is Mr. Saurabh Mitro? Dismissed for default. Next. 23.
Yes, my lord, 23, I am for the petitioner along with the advocate on record, Mr. Gangli. But state respondent is there. My lord, main respondent is the school. And Arjun Rai Mukherjee learned counsel is appearing. And without him, the hearing should not be done, my lord.
All right, why don't you bring him?
The application is there. Addition of party.
By the school.
School, it is a private school. That is a problem. Arjun Rai Mukherjee.
Who has filed the application?
Yes. I have made an application for addition of party as DI.
Yeah.
Earlier order is there, lordships. Earlier order is there, my lord. I have prayed for leave to file an application.
Well, I'm opposing this, my lord. I'm led by Mr. Arjun Rai Mukherjee.
Yes.
And this is that matter.
Opposing what?
The addition. Yes, because this cannot be done beyond the scope of the writ petition, A, beyond the scope of the complaint, and B is, my lord, there is a private unaided institution. So, my lord, whatever complaints they have sought to, my lord, raise after the writ petition has nothing to do with the writ petition. The writ petition was with regard to, my lord, whether
all right, you are here. Let him make his submission. What is it?
My lord, kindly come to page 12 of the application. That letter has been issued by the application means can.
12?
12 pages
of the application?
Yes, madam. Can.
Why don't you go to the writ petition?
Yes,
What is your
writ petition is, my lord, kindly come to main thing in the suspension of the principal of the school, my client, that page, my lord, 39.
Page 39 is a show cause.
Show cause.
Yes.
Yes, and then, my lord, show cause in the same letter on the same date. Page 50. Kindly come to page 50.
Yes.
In the last paragraph, it is made clear that in view of the aforementioned act on your part, you are kept under suspension pending disposal of the disciplinary process.
Yes.
So there is no scope for reply. Violation of natural justice.
Suspend.
No reply.
1 minute. This is a show cause, which means you have been allowed time to show cause.
Yes.
Then where is the violation of natural justice?
Why the suspension will have to be done or not? I should have to reply.
Listen, suspension is a very preliminary thing. It means nothing. What is the position of the disciplinary proceeding?
No,
What no?
no. They will say.
You
my
have
lord,
rushed to the court challenging this.
Yes, my lord, no letter has been issued to me. No proceeding I have appeared. And in the meantime.
Let the stage come. Did you file your show cause?
Yes, my lord.
Where is your reply to the
next
show
page,
cause?
my lord.
They will consider. Please come.
Yes, my
The
lord.
petitioner is aggrieved by
51, page 51.
the show cause notice issued to her on 27th October 2025 by the
Yes, my lord. Reply, page 51, my lord. Annexed at PC.
Kingston Educational Institute by the who is the signatory? HR department.
And the respondent
It
number
has
7.
gone from the HR department.
Acha, by
Respondent number
the
7.
HR department
Yes.
of the Kingston
Secretary is the
Educational
respondent
Institute.
number 7.
Now these are two very widely CEO, HR.
Petitioner is particularly aggrieved as, according to the petitioner, there has been violation of principle of natural justice. Stop. The authority, by issuing this show cause notice, has simultaneously put her under suspension. Stop. The petitioner contends that the same cannot be done. Stop. Prior to suspending the petitioner, comma, an opportunity of hearing ought to have been granted. Stop. It appears that the petitioner has already replied to the show cause notice, but thereafter the matter did not proceed, allegedly because the petitioner rushed to the writ court. Stop. Paragraph. Prayer has been made to set aside the show cause notice. Stop. Paragraph. Learned advocate representing the.
My lord, another thing, 3 months salary has been held up from August to 35.
আর একটা লাইনও লিখে দেবেন তো,
I have prayed.
salary of the petitioner has not been paid for the last 3 months. Are you going to school? You have been suspended. No question of going. Acha.
They have registered to go.
Learned, the prayer of the petitioner is opposed by the Kingston Educational Institute. Stop. It has been submitted that the institute is a private one.
Private unaided.
Unaided. Private unaided one. Stop. The writ petition will not be maintainable against the institute. Paragraph. Without entering into the merit of the prayer of the petitioner, as it appears that the petitioner has approached the court at the stage of issuance of a show cause notice, comma, the court is not inclined to interfere in this matter. Stop. The show cause, issuance of show cause is not imposition of any penalty. Stop. It is a mere opportunity granted to the addressee to reply as to why proceeding shall not be initiated against him/her. Stop. It is a very preliminary stage and it is not proper to enter into the merit of the show cause notice unless and until it is shown that the same is palpably illegal or bad in law.
But only one humble submission. They have not challenged the show cause either. Kindly see their prayers. They've not even said this. This is now being stated from the bar. Kindly see the prayer.
In the pleading, there is
pleading. Kindly see page 15. They have not challenged this.
Achha. The learned counsel representing the institute also points out that no prayer has been made in the writ petition challenging the show cause notice. Stop. Prayer has only made for releasing the arrears salary.
The area salary suspension allowed.
And suspension allowed.
Salary is given, then where is the question of suspension?
Yes. Both can't coexist.
Both cannot.
Both can't coexist.
ঠিক আছে release salary and other benefits entitled in law. Stuff paragraph. এটা না যেখানে সাবমিশন বলছি ইনস্টিটিউটের এই প্যারাগ্রাফটা ওইখানটাতে দিয়ে দেবেন, তারপরে কোর্টের অবজারভেশনটা থাকবে। আচ্ছা, the instant writ petition stands disposed of with the observation that it will be open for the parties to take steps in the matter in accordance with law if so advised.
My lord, kindly application can page 50, your lordship.
As the writ petition is being disposed of, comma, no direction is being passed in the connected application, stop, the same stands dismissed.
But could there we have made that direction upon the DI, he will take a step for the area salary and suspension.
My lord, could I make one humble prayer subject to what falls from your lordship? Would your lordship kindly clarify by one line that this order is not your lordship's opinion on the maintainability of the writ petition? Because otherwise, my lord, they might at a later stage.
Expressed any opinion?
They might at a later stage. That is why I'm only saying. Subject to what falls.
Later stage what? What are you apprehending? You
that citing this order, they would say, see, the writ petition is otherwise maintainable because your lordship has dealt with it. So that is why I was only my apprehension.
I have made it clear that the court has not entered into the issue of maintainability of the writ petition.
Yes, my lord, that is an application for that.
I had missed out.
I have not allowed your application.
Possibly that has not gone in subject to action.
Possibly. DI has issued. There will be inspection.
It is made clear that this court has not entered into the issue of maintainability of the writ petition.
That page 14 of the application we have annexed. After filing of the writ petition, the DI has made inquiry for the inquiry.
Yes, 24.
This matter, my lord, the SSC used their affidavit in opposition, my lord, but the principal respondent hearing, that is the state. Because of that.
The affidavit is lying ready, but it has not been affirmed. I seek 2 days time to get.
Every matter you are doing this.
It is lying ready.
After that, my lord, because of that, in para 2, in the last order,
the advocate representing the state seeks extension of time for filing the affidavit in opposition. Stop. Next. In view of such submission, time to file the affidavit in opposition stands extended for
2 days.
2 weeks.
2 days.
2 days. Acha, 1 week.
My lord, kindly see.
Reply, if any, within a fortnight will be all right with you.
Yes,
fortnight thereafter.
Well, in both the cases, my lord, SSC as well as the state, because of the last order.
The SSC has not filed?
Yes, SSC filed, but the principal respondent here in
state will file, and your reply to the SSC has
SSC as well as the state, my lord, kindly record it, my lord. Otherwise,
reply যেখানে বললাম to the affidavit in opposition by the commission and the state may be filed. Will 2 weeks be all right?
Yes, my lord.
Within a period of 2 weeks.
Already, because of that, plus the SSC's evidence reply is already ready, but until and unless state for
Grateful, my lord.
Release the matter for further consideration on when to list it.
My lord, in this matter, because of that, 5 marks, my lord, is there, and as well as the age relaxation, which is very pertinent. My lord. That matter went up to the Supreme Court, my lord, and the Supreme Court relegated it to this court, my lord. This matter relating to my lord, non-teaching staff, my lord. It will be kind of any my lord, stipulated time. Otherwise, my lord, matter
6th of March.
6th of March, my lord. Grateful, my lord.
25.
I'm waiting for the commission.
There is a direction upon the respondents to file a report, my lord.
Has that been filed?
I have not received anything, my lord.
The direction was given upon the state respondent because the commission has acted on the state's memo.
Who's for the state? Mr. Wasim Ahmed. Mr. M. Shahabuddin. Where are they?
I take it tomorrow. I shall serve notice to them, my lord.
2497.
2947.
Call him. I'm passing it over.
Very good, madam.
Call him. 26.
For the state.
But I am for the this matter petitioner is a job loser in respect of first SLST. But petitioner parallelly participated in the upper primary selection process. Petitioner come in the main merit list, but petitioner did not appear.
The commission was directed to revert. Dr. Patro. Dr. Patro is there.
My lord, this is my instruction, my lord. I have been called for interview. This is the second petitioner number 2, and this is the petitioner number 1. Both have been called for, my lord, counseling process. And my lord, that serial number, my lord, Purnima Soren, my lord, bottom from 5th.
565.
Purnima Soren, bottom from the, my lord.
Yes.
Yes. Both have been called for, my lord, interview.
Why two Purnima Soren?
My lord,
In the female category and the male female category. And this is Orijit Ghosh.
And my lord, sir, already decided that issue, my lord, me too, that I am relying that order, my lord. Already your lordship has decided, as well as my lord, honorable division bench decided, my lord, after my lord, remaining counseling parties, my lord, remaining parties 1242. After 1242, my lord, honorable division bench opportunity is given to facilitate.
Dr. Patro.
My lord, this
candidates were called.
My lord, everybody cannot be allowed to enter the field. Their first communication came in November 2025. Long after December 2025, long after the expiry of the panel, long after loss of jobs. Still they did not come. So these matters, my lord.
Even after 1242 vacancies are filled up, then what will you do with so many vacancies? They were called for interview.
No, I will not have vacancies in which they will be able to be accommodated.
Very well, no question.
But unnecessarily increasing the number of candidates I have to handle.
You handle it only till 1242. Thereafter, all out. Why will you go on handling?
1242 I will give to the designated candidate.
Right, thereafter.
Then whatever few will be left,
the list is going on and on.
It will be given to, say, 5 vacancies for 500 candidates.
No, only if the matching vacancies are.
Match.
Otherwise, no. Because see, in that case, you have to report this vacancy all over again and steps will be taken for filling it up. Isn't it?
In a subsequent
recruitment process. Since they are job losers, this is the reason. Otherwise,
but they lost their jobs in April
2024.
Yes, and in December 2025, they realized that I've lost my job. I want to become a. This is why I'm opposing. Some vigilance is necessary.
Very good ground to oppose, but then at the same time, since it's a matter of bread and butter, the court is little bit lenient. Otherwise, no.
Very well. I leave it to the court, like whatever.
I understand that what is being done is may not be the proper thing to do to put pressure upon you to fill up the vacancies. But since they were already called, this is the reason. Otherwise, Ajay, please come. Learned advocate for the petitioners have produced documents in support of the submission that they were called for counseling. Stop. The petitioners, despite getting opportunity at the counseling stage, did not appear at the time of counseling. Stop. The panel in question has since expired. Stop. The petitioners pray for a further direction. No, further opportunity. Petitioners pray for further opportunity to direct the commission to take steps in the matter. Step next. the prayer of the petitioners is seriously opposed by the learned advocate representing the commission. Stop. It has been submitted that the benefit of counseling ought not to be extended to the petitioners, as the time for counseling expired long back. Stop. The panel no longer survives. Stop. There is already a list of candidates waiting to be appointed against matching vacancies. Stop paragraph. Upon hearing both the parties and in view of the fact that the petitioners are job losers and are frantically looking for a job, accordingly, the court is minded to grant relief to the petitioner in the extent mentioned herein below. Stop. It has been brought to the notice of the court that counseling for 1 to 4 candidates has to be conducted by the commission in terms of the order passed by the Honorable Division Bench on November 25, 2025 in MAT number 1512 with IA number CAN 1 of 2025. West Bengal এটা থেকে অর্পিতা প্রামাণিক। Stop. Paragraph. এই যে set out 8 petitioners হবে and 9 disposed. আবার কি দরকার নেই।
My lord has made it clear that only after exhausting 12
Absolutely.
obliged.
The same direction is here. Only after completion of counseling of 1242 candidates, any vacancy subsists, then only the petitioners may be permitted, subject to availability of matching vacancies. So two things. One is the matching vacancy, second availability of vacancy.
My lord. I'm grateful.
হ্যাঁ পাসওয়ার্ডটা এটা তো বোধহয় সবে পাসওয়ার্ড ইজ দ্য পাসওয়ার্ড নেই all right 20 your leadership wait not today
My lord,
please
But I have
31 and 34 also, my lord, 2 p.m. a matter has been fixed before the Honorable Division.
call when the matter is called.
Not today, my
no let somebody be there.
Very well, my lord. Very well.
27 হবে না?
কি হয়েছে কি
দুটো before my submission, your leadership, but I would like to mention 2 matters for upgradation, your leadership.
Sorry.
Please, your leadership, I
Your Lordship had asked for a report, my lord.
Yes.
Have the report.
Where were you when the matter was taken
I
up?
was there.
Then somebody else is there with you. None appeared. This is not true.
I apologize.
Matter is there. You should have come. What does this say?
My lord, it says, my lord, at present, my lord,
Give a copy to him also. He'll also get to see.
in the last paragraph, paragraph 7, my lord.
Hmm.
My lord, as per the declaration of the headmaster of Rajipur High School, dated such and such, 2 assistant teachers of physical science are working presently in the school out of 5 sanctioned posts in the said subject. Therefore, there are 3 vacant posts occurs in the said in the subject physical science in the school. So there are 3 vacant positions, my lord, at present, my lord. Out of 5, there are only 2.
So if there is vacancy, what is the requirement of transferring the petitioner?
Yes. I transferred to a school where only 160 students and 19 teachers. 15 teachers are surplus teacher. I am also a surplus teacher. Again, I will be transferred to elsewhere.
They will cancel the order of transfer. Possibly this was this the administrative transfer?
Yes, my lord. My lord, may I subject to correction by your lordship, my lord? In the year 2023, my lord, a rationalization policy was introduced by the government of West Bengal.
Right.
And huge number of
Now,
teachers
I
were
followed
transferred.
it. If this is the administrative transfer order and if there are vacant positions, vacancies in the school where the petitioner is performing, then there is no
My
use.
lord, government due to, my lord, subsequently the administrative transfer was challenged before the Honorable High Court.
It was set aside.
No, my lord, not set aside. My lord, Honorable Division Bench presided over by Honorable Justice Harish Tandon, my lord, hold that administrative transfer can be issued by the government, but not prior to the candidate, those who have appointed after 97 Act.
All right.
Prior to 97 Act, in their cases, administrative transfer will not be applicable. That order was challenged before the Honorable Supreme Court. Honorable Supreme Court also affirmed the judgment passed by the Honorable Division Bench of our High Court. But subsequently, in the meantime, 2 years has passed. And ultimately, when, my lord, the Commission as well as the West Bengal Board of Secondary Education tried to, my lord, fulfill the gaps by issuing the transfer recommendation or order in favor of the petitioners, there are certain changes are there.
Right. That
So
is
they are
the
The whole
transfer issue
was cancelled.
was cancelled and all the transfer recommendation issued.
But it has gone
under
back to
10
square one.
That was withdrawn, my lord, by the
now,
government of
as it appears that there are vacancies, the petitioner can be.
My lord, then, my lord, this order needs to be set aside, my lord. My lord, page 31.
Yes.
The order of cancelling the order of transfer
Yes.
will not be made applicable in case of the petitioner.
Yes.
It was
In respect of so many candidates, but so for the mic.
And it will
not
open floodgate, my lord.
what will open floodgate?
Your order, your lordship's order, my lord.
No.
Huge number of candidates will approach before the honorable.
No.
Yes, situation is different.
Thing is, if there are vacancies in the transferee school and the teacher is already teaching over there, then then the main issue was rationalization.
Rationalization.
Then that purpose will not be served.
Yes, madam.
If the petitioner is sent to a school where there are surplus teachers, where is the rationalization? Isn't it?
That is true, my lord. But
Then?
my lord, it is the policy decision of the government of West
Let
Bengal.
it be cancelled. Please come. Peruse the instruction forwarded by the District Inspector of Schools, Secondary Education, South 24 Parganas, signed on 29th January 2026. Stop. It appears therefrom that the petitioner, on transfer, is presently serving in Rajipur High School.
No, Ramrik, my lord. Transferred me Ramrik again. After cancellation the transfer order, my lord, they asked me to join the Ramrik institution.
Right now you are in Rajipur.
No, Ramrik. In terms of the transfer order, I have joined in the Ramrik. Otherwise, my lord, they will.
You want to stay where?
Rajipur.
To the transfer school, my lord, pursuant to the transfer recommendation issued under.
There's only one difficulty, my lord. If this is allowed, my lord, then the order which has by way of the cancellation, my lord, the everything will get, my lord, will be in the catch 21 situation. If one is allowed, then all of them will come with the application and the order will not be compliant.
Ramrik was in 21.
Yeah.
My lord.
And
I
then
was transferred in 23, I was transferred to Rajipur.
yes,
I was there for 2 years. In 2025, they cancelled the transfer order.
But that
Me to again join in Ramrik.
this
But
is
that-
what I am recording.
Yes, my lord.
But that transfer was based on the, my lord, the
If this is your lordship recording or that is correct.
This is what I am recording. কি
But
বললাম?
my lord, all the teachers who got transfer in the year 2023, they have, my lord, reverted to their original posting.
Hmm.
My lord,
But this will become an exceptional case, my lord.
to the government, my lord.
All right,
No,
let
it
me
is
see what can
not
be
my
done.
submission.
On transfer, in the year 2023, was serving in Rajipur High School, within bracket HS. Stop. The petitioner was initially, no, the petitioner was appointed as assistant teacher in Routara, Routara, Mahendranath Memorial High School, Habra, in the year 2013 and stood transferred to Ramrik Institution Higher Secondary Bhawanipur on 26/12/2021. Stop. In line with the rationalization policy adopted by the West Bengal Board of Secondary Education.
My lord, by the government of West Bengal.
Acha, by the government of West Bengal, the West Bengal Board of Secondary Education transferred the petitioner to Rajipur High School as he was a surplus teacher in Ramrik Institution. আচ্ছা রাজীবপুরে ট্রান্সফার করলো in August 2023. ঠিক আছে? On cancellation of the order of transfer dated 11th April 2025, the petitioner has been directed to revert to Ramrik Institution. Stop paragraph. The petitioner submits that he will remain as a surplus teacher in Ramrik Institution. Stop. The petitioner prays that he may be permitted to continue in Rajipur High School as there are vacancies in the said school. Stop. Next. The report of the District Inspector of Schools mentions that as per declaration of the Rajipur High School dated 28th January 2026, 2 assistant teachers of physical science are working in the school out of 5 sanctioned posts. Stop. The same implies that there are 3 vacant posts in the subject physical science in the school. ঠিক আছে? Paragraph. Learned advocate representing the commission and the state respondents submits that the
Well, I'm only representing the state respondents, not the commission.
the
তুমি commissioner আছো, তাহলে।
transfer order was cancelled by the Deputy Secretary to the Government of West Bengal. By taking an administrative decision. Stop. The by way of the transfer order, comma, several teachers were transferred from one school to the other only for the purpose of implementation of the rationalization policy of the state. Stop. Surplus teachers from schools were transferred to the schools with deficit teachers. Stop. Paragraph. It has been submitted that as the order of cancellation of the transfer order dated 11th April 2025 was passed in respect of was passed en masse, EN-MASSE, in respect of teachers, any order interfering with the said order of cancellation may open floodgates and teachers who have been directed to revert to their earlier place of posting may approach the court for relief. Stop. Paragraph. The court has considered the submission made on behalf of all the parties. Stop. Admittedly, it appears that the order of cancellation of transfer impugned in the instant writ petition was not passed only in respect of the petitioner, but was passed in respect of several teachers. Stop. Many of the teachers may have accepted the said order of cancellation of transfer and may have joined their erstwhile place of posting. Stop. The case made out in the instant writ petition, paragraph is that the petitioner was a surplus teacher in the earlier school from where he was transferred in the year 2023, and on cancellation of the order of transfer in the year 2025, the petitioner will once again be a surplus teacher in the said school. Stop. On the other hand, the school where the petitioner was transferred for implementation of the rationalization policy has vacancies where the petitioner can utilize his services. Stop. Next. In view of the above, the Deputy Secretary to the Government of West Bengal is directed to revisit the issue of cancellation of the order of transfer in respect of the petitioner, keeping in mind the rationalization policy of the state. Full stop, and particularly because of the reason that the petitioner was transferred to a school which had vacancies and still have vacancies. stuff. Next. A decision shall be taken by the Deputy Secretary to the Government of West Bengal at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Was any interim order passed? Have you joined Ramrik?
Yes, madam.
All right. Be it recorded that the petitioner has acted in accordance with the order of cancellation of the transfer order and has joined Ramrik institution in the meantime. Next. Disposed.
Wait, Milord.
Transfer matter.
What is the position now?
The position, Your Lordship, page 29. Utkarsh portal I have made. Now the headmaster keeping it pending, my lord, without sending it, without my lord making any no objection, showing any no objection certificate.
Transfer on which ground?
Distance, my lord. My lord, the residence is Nodia. Now he is working near my lord.
Acha, school. All right, disposed. Next.
I don't know.
28.
Oh, Mr. Congress.
29.
Commission, but I am for the petitioner, my lord, transfer on general ground, my lord, single teacher issue. My lord, status is, my lord, page 17, 17. DI back on basis of my lord, single teacher issue.
Is the position the same from 21 to?
Yes, my lord, same. I am a single teacher. Give me liberty to file a fresh application, not observing the
all right.
same by Rupok Dhua ratio, sir.
Single teacher.
Application was back for single teacher. Last application remarks
Last application.
No, it is returned only because of the.
Yes, single.
That was in 29th of September.
Last application was returned, only returned.
3rd November.
3rd of November.
R something is
returned. It is returned short form of
same thing.
No reason.
No reason means the same thing. Single teacher, fresh application to be made.
Great.
Lordship appearing for state.
And school will consider.
Great.
Great.
Well, I'm for the commission, madam.
Petitioner? Yes.
The copy, Justice, the copy has been served, but unfortunately the affidavit service has been misplaced.
All right.
So I am praying for on-week accommodation so that we can serve.
What is the merit of the matter?
I am for the statement. Transfer.
Transfer? Well, why are you seeking transfer?
Because it is more far. The petitioner is very sick also, and her home is very far for her school. It is about 127 kilometers.
Single teacher?
Yes, single teacher.
Fresh application to be made. Head of the institution will consider.
Please pull. Great.
Disposed. What is your name?
Mohua Ghosh.
ওনার নামটাই শুধু দেবেন. Yes.
31 my lord, Mr. Shubhrapakash Laidu is appearing on behalf of the petition, and he was appearing another courtroom, my lord. It is fixed 2 p.m. matter, my lord. Room number 11. I'm praying for only not to the matter.
There are some others. He has other friends, isn't it? Where are they? This is the transfer matter.
This is a transfer matter, my lord.
Then, what is the ground? Commission, are you there?
Single,
Single
previous
teacher.
application was rejected by the HY on the ground of single teacher. Last
Where is it?
application is still pending. Page 19.
19. All right, let it be passed over. Let him come.
My lord.
Next.
Acquisition. Not for the commission.
I'm for the commission.
This is my application for transfer, which was rejected at the ground of single teacher by the district inspector.
Page.
Kindly seize my page now 24 once. But 24 my lord, serial number 2 my lord sees. The reason also kindly sees. I pray. I'm sorry.
Page number?
24 my lord.
24. Yes.
Page number 24, serial number 2 my lord sees.
Uh-huh.
The reason also sees. This has to be set aside.
2022.
DI sends to the application.
That is my lord, the 22nd.
Single teacher, fresh application to be made.
But since it is rejected, my lord, should I just make
No, the rejected 22 and we are in 26.
True, my lord.
So I am mentioning Rupak.
Grounds the same, my lord, subject to law.
I am mentioning Rupak Duha.
I know, ma'am.
And then fresh application, the head of the institution will consider.
As your lordship pleases.
Yes.
This rejection, my lord, be kindly with
Impugn rejection quashed.
the affidavit of service.
Disposed.
Sudeep. Hey, Abdur. I'm for the commission.
My lord, this is a distance ground transfer application earlier rejected by the school on ground of 10%.
10%.
My lord, staff strength has augmented and new teachers joined. So give me liberty to file a fresh application, which shall be considered by the school authority.
All right.
Great.
10% fresh application. Head of the institution will consider.
Great.
Wait.
34, my lord, is the same matter, my lord. I'm praying for a short passover.
Pass over.
কার জন্য?
শুভম কুমার সৌগত মিত্র আছে
For the petitioner, my lord, Dr. Patro is coming. Page number 27. A single teacher that has been rejected on the ground of single teachers, serial number 2. But it's same as the previous one. One may I just make one submission to your lordship. But since this application, true, it is, my lord, back in 2021, though it is of 2022, my lord. But making this new application, lordship, will once again, my lord, lingered the process. If since the rejection is itself, my lord, illegal, but if it should be, my lord, considered after that, my lord, after your lordship's direction. I was just requesting, my lord, making a fresh application will once again, my lord, take some more time. So this is why also.
So from 22 to you waited till 26. And now you want
I said that I
to go at a galloping rate.
I challenged it 2022 itself.
I understand.
But I just request because
For
other
reasons
matters.
best known, it is pending. I am setting it aside
Yes.
and then directing them. Single teacher issue, fresh application.
One problem we are facing.
Yes.
Since my lord, your lordship is ready to file a fresh application, since the portal is suspended.
I am mentioned offline.
No, that issue. But since my lord, new vacancy, they are unable to find out the new vacancy. But only one
When
line
the
be added.
portal was not there, then also they could identify
Only one
vacancies.
line DI could cooperate, my lord, that they have vacancy position. Otherwise, my lord, they.
Is it a case that the DI is not cooperating?
Yes, certainly.
DI is not cooperating.
Not giving. But while learned print is there,
What?
it is, well, it is there. Only one line be added. DI will cooperate for the find out the suitable vacancy. Otherwise, well, they are unable to find out the vacancy.
1 minute.
If I
The application is made before the school first. It goes to the DI.
No, my lord, when the application is made, we have to fill up the vacancy position.
Yes, in the distance ground.
Vacancy position around how the petitioner could ascertain the vacancy.
I am trying to, my lord, understand here. But when this particular portal was offered to you, at that particular time, my lord, we used to
To
see.
see where the vacancies are there.
So
Now you all cannot see.
In the portal, there are so many wrong, my lord. Therefore, the re-recommendation issue has been coming before your lordships. My lord, portal is being operated by the Commissioner
When
of
the
School
portal was not there.
Not there.
Right.
Then also, my lord, they have.
Applications were filed.
There must be an advertisement. This particular school are vacant. Basis of that application, before Ssc, that application, these particular vacancies are available, you may apply. Basis of that, they are apply, incumbent are apply. But now, my lord, this scenario, neither advertisement or nor my lord portal. So they are facing some only one line we added. District inspector shall cooperate to available the necessary vacancy position.
I do not understand. Your line is very vague. How will the DI intimate you that there are vacancies?
I'm trying to.
And why, my lord? Why also, my lord?
May I-
Why it is their stake that they are trying to
Out where
find
there
out
are
the vacancy,
vacancies.
then make an application.
May I try to
Yes.
answer this, my lord? Because this situation, my lord, happens when, my lord, this portal is suspended. So when it is suspended, we cannot just see the portal. What are the vacant schools? So now, my lord, what happens here today, my lord? We are facing with some of the the recent order from the commission also that you have chosen this school, but we have forwarded the vacancy to the 2026 election selection process. So, my lord, this is why what my learned senior perhaps what my learned senior friend was suggesting, that would be, my lord, my suggestion will be, my lord, that now today we are making application afresh. So, my lord, if we could just, my lord, get to have the assistance from the, because school does not have the authority or the database. The district inspector has got the databases in which, my lord, the schools are vacant. So if we could just get some assistance from the district inspector about the vacancy of the school.
You make an application. See, this way it cannot be done. You have to make an application before the DI
Follow my
to take information whether there is vacancy or not. Why will the court direct?
No, court direction, my lord, we are not praying. Only what my lord senior, my lord, prayed. It's in my opinion, my lord, I will be just adopting his submission. If the district inspector at least could, my lord, cooperate with the petitioners with respect to the vacancies, nothing else.
For that, they can make an application under the Right to Information Act that you disclose what vacancies.
For the board also.
Or the board,
Board is the vacancy.
custodian.
Then I have to
Roster making of it.
three schools.
But I'm sure my learned senior, my lord, is not standing in the way of the rule to be, my lord, implemented in its letters and credit. So, my lord, for the purpose of the rule to be implemented to its letters and credit, if one of the machinery of the state could extend some of the supports, that is
Guys, methods as to how they can
so otherwise,
show the vacancies, then it is up
it is
to
not
them.
in honorable court's domain. I follow, my lord.
I cannot.
I just
Fresh
request my, since
application.
we are making this new application, that is the difficulty.
No. This post.
Great.
36.
But the affidavit.
Service to
Great. My lord, this is a single post, my lord. This petitioner before your lordship, my lord, is a non-teaching staff. My lord, his application, my lord, has been page number 24, my lord, says rejected by the school on the ground of being it to be a single post. Serial number 1, my lord.
But then Rupak Dhua is in case of teachers. It cannot be applied over here.
My lord, it is, my lord, the answer your lordship will find from the rule itself.
Yes,
The rule, my lord, says that the provision of teachers will be applying mutatis mutandis with respect
In
to
respect of non-teaching staff. Please show me that.
Which your lordship will find at page number 33 of my writ petition. My lord, 33 is where the rule is already started. So, my lord,
Yes.
so rule 10.
Procedure for non-teaching staff.
In case of non-teaching staff and
Yes.
librarian, desirous of general transfer under this provision of this rule, the provision of this rule shall apply mutatis mutandis.
Please come. It a single teacher hobe na? Single group D post in the school.
My lord.
ঠিক আছে রূপক ধুয়া হবে একটা লাইন অ্যাড আপ হবে as the law dealt with in the matter of Zuha within bracket supra is applicable in respect of non-teaching staff also, comma, accordingly, the ratio of the judgment in the matter of Rupak Duha shall be applicable in the case of the petitioner. ঠিক আছে? 24, 21. Fresh application to be made. Considered by the head of the institution. Disposed.
Grateful.
Okay, do it, no?
But for the petitioner, but there is the affidavit of service. But I have been instructed by the client after he files this writ petition, his grievance is met.
All right.
But I cannot withdraw this lodge. You can record my submission, make this.
Yes, yes. Learned advocate for the petitioner submits that during the pendency of the writ petition, comma, the grievance of the petitioner has been redressed. In view of the above, there is no requirement of passing any order in the instant writ petition. Stop. The same stands dismissed as infructuous.
38 for the petitioner. This is also application for transfer. It has been rejected by the, it was rejected by the school authority, or rejected on the ground that rejected for issuance of NOC, that the school has shortest teacher, page 43. But the two wise, before that there were several application made, but the last two application were I'm placing my lord, page 43.
Yes.
Well, the first, no, the number of teachers being very few in respect of no stay. Then well, second also, her application was forwarded twice, but it was returned twice. The school authority.
Is the position same now? No new teachers have joined or not?
Okay, subject to correction. Well, the school is having a 20 teacher. I am a subject of English. In respect of English, there is a 5 teachers. And there is a 1 para teacher. Despite that, since the school authority has repeating, and no objection cannot be barred. No what is the school authority cannot. There is a several judgments.
Achha, the petitioner's application seeking transfer was not allowed by the head of the institution on the ground that the number of teachers in respect to the number of students in the school is very few. Stop. The application was returned to the petitioner on 30th January 2022. Paragraph. Learned advocate for the petitioner submits that there are 20 teachers in the school. How many students?
Well, the paragraph 12, kindly see. Last 3 lines. Paragraph 12, last 3 lines. Is pertinent to mention here that the teacher strength of the school permanent teachers 17 and para teachers 3, total 20. In the subject English, there are 5 teachers and also para teacher was 6.
That there are 20 teachers in the school, out of which 5 teachers teach English and 1 para teacher also teaches English. 5 teachers and 1 para teacher teaches English in the school. Stop. According to the petitioner, there is no dearth of English teachers in the school. Stop. The petitioner submits that it is absolutely illegal and improper for the school to not issue no objection certificate in favor of the petitioner. Stop. Next. It appears from records that the application of the petitioner stood returned way back on 30th January 2022. Stop. Nearly 4 years have elapsed from the date he said application was returned. Stop. There may have been change in the staff strength in the meantime. Stop. Next. In view of the above, fresh application করতে বলা হচ্ছে।
Not only my humble submission, but the authority and the DI will consider considering keeping in mind the Gokul Chandra Mullik and Rupakdwa because of again it might be the rejection of single teacher. Only this paragraph.
But you are not a single teacher.
No, I am not single teacher.
6 teachers in the school.
But since 2020, 22 to till date, maybe it is there are teacher has been transferred or coming. That we do not know.
Maybe new teachers have also joined. You never know.
The teacher could have found out. The teacher who is teaching in the school was not released, and whether her colleagues have left the school or are still there, she knows better. Let her instruct.
That's why only
knows.
And one of the
The issue
reasons
has
for
been
rejection
settled.
was also low rank. When the SSC returned it, that why learned friend did not point out.
That is not I am challenging because of last kindly.
We sent it back due to low rank.
Yes, that is
So
correct to that.
Acute shortage. 1st of December 21 also mentions about the acute shortage of teachers.
Yes, and
last
Return
application
is
kindly
no
read page 44.
No vacancy. No vacancy.
No vacancy in the school where I want
Page
to transfer.
44, serial number 7,
Serial number
returned
7.
due to low rank. So there were other candidates above her requesting
So
the
that is
same.
kindly my line has relying on 2021 application and last rejection in 2022. But my learned friend were trying to mislead before this court.
All right.
I am submitting correct things. You also try to do the same.
Fresh application করতে হবে. Head of the department will consider it.
Will only show the line which suits your client.
My lord, in item number 37, I am appealing for the state resume. May I?
All right, give the slip.
That is a show. Order for the petition. Page number 31, Lordship kindly sees it has been rejected by the school on the ground of single teacher. Serial number 2.
All right. Single teacher. Fresh application. Head of the institution will consider impugn rejection set aside.
Lordship is mentioning my lord's Rupak's statement.
Yes. Disposed.
I am for the petition. But here, my lord, my application that on the ground of my wife's medical condition has been rejected by the district inspector on the ground of single teacher. My lord, I'll seize this order once.
Page.
Page 26, fine. At page number 26. Is this one? 40. Second paragraph would not be applicable. Sorry, third paragraph. Second order. Page 26. But at the same time, my lord, your lordship, since my lord, nearly 4 years, your lordship, my lord, direct the CMO is to take a fresh, my lord. House medical, right?
CMO is not even a party.
No, party দরকার নেই, DI পাঠাবে। কি order দিয়েছেন?
Or
What she has already directed in this order, if required medical examination to be done. Already আছে দাদা। That is a paragraph number 8 of the order. If required medical.
All right, same order. I have made the necessary correction.
Paragraph number 8, lordship has seen, my lord, it would be, my lord, district inspector, not the head of the institution.
great.
Instead of second.
It was rejected by the school managing committee,
Yes.
My lord,
by the district inspector.
this is why I was praying.
That's page 26.
Corrected. Head of the institute, it would be, my lord, district inspector, and my lord, on the next page at paragraph number 8, let it be, my lord, the CMO each of the institute.
ছিল না আগের দিন ছিল
তিন চারবার কল হলো থাকে ইনফেকশাস হয়ে গেছে তাই না
All right.
But DI will reconsider and he will take into account the opinion of the CMO.
Great. Great. With the affidavits.
I am for the state.
I am for the secondary board lordship.
But the matter was call for 2 or 3 days. Petitioner never appeared, lords.
Dismiss for default.
Please.
Brother Babu, none appears for the petitioner on repeated occasions.
42, my lord, Mr. Orpo Chakraborty is appearing on behalf of the petitioner, my lord.
Where is he?
My lord, he perhaps has not come, my lord.
Oh, yes.
He is seeking 1 day's accommodation, my lord. Only one.
Why Mr. Ujjwal Ray will not?
No,
Mr. Chakraborty will be, my lord, hearing, my lord. Been told, my lord. No, 1 day's accommodation, my lord.
Not today.
Monisha Sen has qualified. Our instruction.
Qualified where?
In the SSC test.
But yes, but
If she is qualified today, she'll be qualified tomorrow also.
I'm great.
Matter may be disposed of.
Let the petitioner come and say.
Very
Grateful.
পরেরটা বল। রাহুল মন্ডল।
I'm for the state of.
Where is the petitioner? Ambia Khatun? No, they have. No, nobody is interested. No, but this is a new matter. SLST, here the candidate has passed or what?
ইনস্ট্রাকশন আছে পাস করেছে কিনা বলতে পারবো না। This is the question.
Dispute. What happened?
They have not passed. They have not passed. The results are annexed.
Results are annexed?
Yes, results are 82 to 86.
And how many questions did they object?
The question objection is question numbers 32, 45, and 50. Pertaining to not all the petitioners. Prayers are at page 16. Kindly comes.
Three questions objected, and if the
only to the petitioners. No, not all. Not all of them did not object to this.
right.
Then, their
So
prayer.
there are petitioners who did not object.
Yes.
At any stage.
No, yes, that is my
means
instruction.
maybe the preliminary answer key it was proper.
Yes.
Assuming 3 marks is awarded, 3 marks are awarded.
Insofar as our instruction is concerned,
yes,
there was no objection raised as per Rule 5 of the Rule Roman 5.
Tell me, assuming 3 marks are awarded, will any of the candidate pass?
It kindly comes back to the results. Please see 82. Page 82. He has secured 52. The full marks is 60.
No chance.
Similarly, 54 and 60 is the next result that is annexed. 84.
82 and then 54.
84.
84. 51 and 60.
51 and 60 is 86.
Oh, 54.
84 and 54 and 60.
54 and 60, no scope. 85 also, how much? 67, total marks is 67, cut-off vacancy 66, 85.
Yes.
This candidate possibly have passed.
Yes, possibly.
86.
86 is 51 and 60.
No chance. So only one candidate?
There are total 6 petitioners. 6 petitioners.
What about other marks?
They have annexed.
They have?
82 onwards are the marks. 82, 83 is another thing. I missed it. 58
83.
and the cutoff is 70. 82, 83. 84, 85.
Result of written exam.
Yes, written examination. Only one candidate, what I find is.
May get a chance.
Yes, candidate information.
All 4 out.
His name is Hajikul Alam.
Have you prepared a report?
No, not yet. No report.
Direction was not.
No report.
And did he raise any objection?
I'll just check. My instruction is no objection.
Was his answer proper at the preliminary answer key level?
I'll check. Please come to page 53. Now, question 32. Milord, question 32. Question 53. Question 32. 45 and 50.
Question 32, 45
Yes.
and 50.
Yes. No, the I think a report is, we'll file a report indicating everything. But prima facie, most of the petitioners do not come within the cutoff.
respect of
Cutoff is, of course, inclusive of educational. This cutoff thing.
Whatever. None appears on behalf of the petitioners at the time of call. Stop. The petitioners participated in the. There are 6 petitioners. What about the 6th one? You've given 5.
The 6th one. No, just give me 2 minutes. I'll find out.
The. Acha, theek hai. Wait, I'll take care of it. The petitioners have raised issues with regard to the manner in which their answers have been assessed. Stop. Paragraph. The petitioners have annexed their mark sheet. No, not mark sheet, the result details, wherefrom it appears that some of the petitioners will not be successful even if marks is allotted to them in respect of the objections raised. Stop. Accordingly, the writ
petitioner results are not.
Accordingly, the writ petition is treated to be dismissed in respect of those candidates who did not secure marks. Marks which, on addition of the questions objected to, will take the candidate to reach the cutoff marks. Stop. The commission is directed to revert with a report by 25th of February 2026, only in respect of the candidates who may reach the cutoff marks. If the objection raised by the petitioners is found to be proper. List on 2nd March. A copy of the report shall be served upon the learned advocate representing the petitioners.
Item number 44, I am for the petitioners.
And I am appealing for this case.
Affidavit service and the short written notes.
Yes.
The petitioners respectfully submit that the court may be pleased to constitute an expert committee or appoint an independent expert comprising domain specialists in chemistry, preferably from professors and associate professors from reputed institutions such as IIT and IICR, or other neutral academic bodies outside the direct control and influence of WBSSC or the State Education Department.
Sir,
to examine, assess.
Tell me the facts of the case first. What you want? What is your grievance?
My grievance is question number 47 has been incorrectly evaluated by the WBSCC. I want
question number 47. Only one question.
Only one question.
How much marks did you secure?
Only one for one. If I get 1 marks, I'll be called for interview.
Both the petitioners.
Only petitioner number 1.
And the second petitioner.
Second petitioner requires 2 marks.
So you are not proceeding.
Only for one, petition number 1, I want to proceed.
For 2, it will be treated as dismissed. All right.
For 1,
For 1. Now show me what is your answer. Where is the question?
question number 47.
What is the question?
Page, I'm showing lots. Page number 38 of
Right.
the writ petition.
Yes.
Identify the correct statement for an ideal dilute solution.
Right. What is the answer?
Petitioner opted option A. Both
right.
of solute and solvent obey Raoult's law. I have annexed the P4 and P5 as a writ petition, which shows my option is correct.
Show me.
47.
Page 57. Second para. Real solutions follow Raoult's law more closely as a solution becomes more dilute. The ideal solution is defined as one that follows Raoult's law over entire range of concentrations. Both solute and solvent, entire range of concentration. This is one authoritative book. Another authoritative book is there. Page 62 of the writ petition.
Yes.
Ideal solution. An ideal solution is that solution in which each component obeys Raoult's law under all conditions of temperature and concentration. So both solute and solvent will obey the Raoult's law at all temperatures and concentrations.
All right. Now, what is the answer given?
Another
by the
answer?
Answer given by
B.
the commission in the
B.
preliminary answer key.
They have quoted the option B.
Preliminary answer key.
I'm just checking that.
It's not annexed.
B.
It is not annexed. Preliminary answer.
Did he? What is your answer? Preliminary answer.
My instruction is, against serial numbers, question numbers 41 to 47, whatever is the preliminary answer key answer, they are correct.
It's question number 4 of
Whatever is the preliminary answer key answer, they are correct. And did the petitioner object? He didn't object in the.
I objected by representation.
When did you object? At the preliminary stage.
Preliminary stage, I objected.
Show me.
Objections.
Objections. Right.
Please show.
Annexure P6, page 73.
No, your registration, sir.
This is by mail I sent. Page 50.
Page 50. If I am not wrong, kindly check.
You are
Page 50. Page 50.
No, his question number is 31.
47.
Question number is 33. Question number 47.
47.
Yes. SSC uploaded answer is B. Suggested answer.
Sher Khan.
Sher Khan is the appellant number 2. I mean, petitioner number 2.
It's your objection. You are the petitioner number 1.
Petitioner number 1 and 2. I'm representing both petitioner 1 and 2.
But for item number petitioner number 2, you are not proceeding with the writ petition. So the one left is Piyush Niyogi.
No, I have annexed it. Petition number 2, page 53. Page 53.
Show me that.
No, please don't. No, we are concerned with
page 46, page 53. Question number.
Right now, the writ petition is being proceeded only by Piyush Niyogi.
Piyush Niyogi.
Show me that Piyush raised objection at the preliminary
page
stage.
50. Page 50.
Page 50 is Sher Khan.
No, Piyush Niyogi.
Oh, 50 is Piyush.
Piyush Niyogi.
And question number
47. Page 51.
51.
50, last one. Page 50.
End of page 50.
End of page 50.
Question number 47. Uploaded answer, model answer key is B, suggested answer is A. All right, now show me what the expert has said. Expert has accepted whatever is there.
What is here the printer? We don't want to go. Expect to be.
The expert says that whatever was there in the preliminary stage is correct.
My instruction is, the expert has said question numbers 41 to 47, whatever the option provided in the preliminary answer key are correct for 41 to 47.
That means,
Hi.
right. Now there are books.
Authoritative books are there annexed to the writ petition.
These are science, questions of science. How can there be such discrepancy? I do not know. Ajay, please come.
Now, my lord, I do not know what your lord.
I am thinking of sending it back to you for revisiting.
Expert committee may please come.
No, not expert committee right
And
now.
I place my reliance.
See page 47 for a moment.
47.
Final answer, question number 4.
47.
47 is, serial number, question number 47.
Serial?
It's a B. This is the 47 booklet series for
Chemistry.
Yeah, booklet series.
Here.
7. It's the master key. It is 4.
Yes.
Answer is B.
This is our, this is the final answer key.
What?
Serial number 47, section, question number 47.
Marks to all.
No.
Page 47 you are showing?
47 is not a part of the writ petition. It's a final answer. Yes, this is the final answer. Final answer is copy.
No, page 47. Were you referring to page 47 of the writ petition or what?
Yes, of the writ petition.
It is a chart.
This sort of a chart.
Yes, it is a chart.
Yes, this is the master answer key, final answer key. Kindly sees
question number 47.
47. The final model answer is B.
Question number 4 is the main is the number in the master answer, like master answer, final model answer B, which pertains to book series B.
What? Yes, I cannot follow. What are you showing from
question number 4, serial number 4 in the master key.
In the master, serial number 4.
It corresponds to question number 47 in the booklet series B. The final model answer is B.
B. All right.
According to the commission.
Yes.
This is the final model answer.
Right. And
he says it is A.
Right.
Now, whether, in this sort of because this issue, I'm indicating it to your lordship. Your lordship was pleased to reject certain prayers. Now, your lordship similar order.
Yes, I'm aware. I have dismissed matters.
And those matters have been carried in appeal. The appellate court, we are arguing. In fact, in the other day, we had produced a compilation of judgments, as to how far this issue can be stretched in a writ court. Now, we are heavily relying on 2021 volume 2 SCC page.
Yes, but then I do not know. This is a chemistry answer, right? So
the examination process, it perhaps, with greatest of respect, some sanctity has to be given to the experts in the relevant field. He might be relying on books, whether how far those books.
Those are authoritative books of master, postgraduate books are there.
This is exactly the reason as to why the court is thinking of, in English, in Bengali.
With all humility, if this order is passed, someone else is going to come and persuade your lordship.
All right, do one thing. Let us wait for the appeal court to take a decision. I'll keep it pending.
Justiceship, just one indulgence is there. I rely upon a Supreme Court one judgment.
And Rule 11.6 may kindly be looked into before my learned friend says. Kindly sees Rule 11.6.
The expert's opinion is the final one. I'm aware of it.
And so therefore, my lord, in such a situation, my lord, unless your lordship recalls, my lord, previously, my lord, these sort of matters, my lord, while your lordship was on this side, if your lordship very kindly recalls, my lord, Honorable Justice Barin Ghosh used to deal with these sort of matters, my lord, when prima facie something is shown. Extremely, my lord, not by logical reasoning. What the Supreme Court is deprecating, my lord, is logical reasoning. This maybe that is a logical reasoning. Unless, my lord, someone writes, my lord, red blood corpuscles to be RBC, and despite writing red blood corpuscles, my lord, someone has been given a 0, then perhaps, my lord, your lordship would, without applying any logical reasoning, my lord, whatever, my lord, what the Supreme Court, Honorable Supreme Court, your lordship's court, innumerable judgments, my lord, unequivocally say that, my lord, this domain, this is
Yes,
exclusive.
it's expert's domain.
I-
Show it to your learned. Give the citation.
Citation 2017 INSC 1209. In paragraph 30, the
What is the
Supreme Court
name of the parties?
name of the partners. Run Vijay Singh and others versus State of
Vijay was considered possibly.
I'm just giving.
There is a 2021 judgment thereafter. Go through that. All right.
This is it's just given one few seconds.
No, second.
If a statute, a rule, or regulation governing an examination does not permit revaluation, then it may be allowed by expert committee.
We are not permitting devaluation.
You are not permitted, but independent expert committee may please
The
be appointed.
independent experts committee has been completely ruled out, my lord, by the Honorable Supreme Court. Innumerable judgments.
Submits that.
Then I may please be given
The
opportunity
petitioner
to go
number
through the
2.
compilations, and then I'll come back, Lordship.
Vijay Singh is a part of this compilation. It's 22
will
to SCC.
not proceed with the instant writ petition.
Where he says the Run Vijay Singh has been abrogated.
In
And Vijay Singh has not been abrogated.
As the second petitioner may not be able to reach the cutoff marks, even if the question objected to by him is marked in his favor. Stop paragraph. In view of such submission, the instant writ petition stands dismissed in respect of the petitioner number 2. Stop paragraph. The writ petition is being considered only in respect of the petitioner number 1. Stop. The petitioner raises objection with regard to the manner in which the answer in respect of question number 47 has been assessed by the authority. Stop. According to the petitioner, the answer given by him to the said question is correct, and the petitioner relies on study materials in support of this submission. Stop. The petitioner has marked answer A to be correct, whereas according to the preliminary answer key and the final answer key published by the commission, answer B is the correct answer. Stop paragraph. Learned advocate for the petitioner prays for appointment of a fresh set of examiners to examine the disputed question. Stop paragraph. Submission of the petitioner is opposed by the commission. Stop. It has been submitted that as the expert body has opined that answer B is the correct answer, accordingly, the writ court ought not to interfere in this matter. Stop. Prayer has been made for dismissal of the writ petition. Stop paragraph. Learned advocate representing the commission that commission apprises the court that an appeal from a similar issue as to whether the writ court can direct re-evaluation is pending consideration before the Honorable Division Bench. Is the mat number there?
At the instance of the, I'll give you the lordship the mat number. The mat
In
number
mat-
is, it is, mat 30 of 2026, Shwani Bhattacharjee versus State of West Bengal.
Check করুন আমার। How do you spell Shawnee?
I'll just give you a lordship. Just 1 second.
Versus commission. ঠিক আছে? Paragraph. As the issue is presently before the Honorable Division Bench, accordingly, the hearing of the writ petition stands adjourned for the time being. Stop. It will be open for the response affidavit in opposition within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop. The candidature of the petitioner shall abide by the result of the writ petition.
SWAONI. SWAONI Bhattacharjee. It's mat 30 of 2026.
Versus the commission?
Versus the state.
State. ঠিক আছে? 4 weeks, 2 weeks. Acha, affidavit of service is written with the records. Take this back, the short notes at the time of final argument. সার্ভিসটা থাকবে, এটা ফেরত যাবে।
ভূমিকা আছে।
Affidavit of service on a captain.
Yes.
One of the petitioner herein is an untainted teacher, my lord. He participated in the both the selection process 9, 10 as well as 11, 12. My lord, the petitioner, my lord, fill up the form. The form is annexed with my writ petition, page 52 and page number 54, my lord. And his name featured in the untainted list, which is annexed with my writ petition, in page number 30, my lord. Inadvertently, misunderstanding, my lord, because he is a teacher of 9-10 category in the first SLST 2016. But he fill up his form in 9-10 as well as the 11-12. My lord, is well aware of the fact that in rule 2025, it's a merged rule, because earlier rule was that, my lord, the first SLST 2016, there was a separate rule for 9-10, there was a separate rule for 11-12. Here, my lord, what happened in the second SLST 2025, my lord, the state government, they issued that rule combinedly. For that reason, they give benefit to the secondary teacher in higher secondary. But here, inadvertently or misunderstanding, whatever the reason, he not given his experience marks in the 11-12 category, my lord. She wants, my lord, his marks might be maybe considered in the 11-12 category. In that occasion, she will come in the zone of the consideration, my lord. It will be kind enough if my lord considered it, because it's a minor error, I believe so. But in this regard, my lord,
It's a major error.
My lord's order, I have handed over to my lord's officer. This issue has been dealt with on 24th November 2025 in Jharna Bishwas, WPA 26534.
my lord, I don't know if my learned friend give that order.
Check up that order and come back.
My lord, yes, I can, my lord.
দেখ এটা দেখ এখানে পড় না একই issue